April 21st. We have a few bills we're going to deal with. S14 we're going to start with and have further committee discussion and possible vote. So over to you, Ben. Tell us where. Now, before we do it, this morning, I understand I wasn't able to be here. There was a walkthrough of where we are.
Yeah, I think we're just ready for the vote.
So we're just ready for a vote. Okay, unless there are other questions, I can get a motion on the floor, on the table.
I make a motion to approve S14.
Next, to concur with concur with further instance of amendment, right?
I make a motion to concur.
Oh, is that how you say? All right, do you just say concur with the strike, or do you say concur with further instances of amendment?
It's a good question. I just say draft 3.1.
Yep.
I think it's just concur with further instances of amendment, whether it's a strike all or not.
Then the motion is to concur
With further instances.
with further instances of amendment on S14.
Version
3.1.
3.1, thank you. Is there a second?
I mean,
Is there any further discussion? Yes, Angela.
well, I just want to thank Representative Dolan and everyone who worked on this. I think it takes some steps in a very positive direction and acknowledge, I would say there's, some more further clarification and more work to be done, but this is a really encouraging step. And it was great for me to see, from my perspective, the kind of identifying an issue that arose through the normal course of business. I know that there was history to it, but as far as my view into it being just this session, it was just great to see that happen, that there was a problem identified and then all this work going into trying to help. So I appreciate that.
Yeah, I thank Karen definitely for all the work. It's been quite a path to get to this. It's not as big of a step as we hoped for, but it's an important step. So any other comments or discussion? Not seeing any. The clerk can call.
Andriano.
Yes.
Arsenal.
Yes.
Chapin.
Yes. Yes.
Plant, yes. No. Is he coming back today?
He's just at a meeting right now.
Oliver.
Yes.
Rachelson.
Yes.
Christie.
Yes.
Burdick.
Yes.
Luell.
Yes. Excellent. And Karen is reporting this, so thank you very much, Karen. Since she knows it inside and out. All right.
Seconding it?
That was Ella. Karen, sorry.
Who,
First did it?
Angela.
yeah.
I did.
It was right,
After several attempts.
Karen Ella or Barbara Joe.
You can really tell it's Friday afternoon when it's really sunny outside, I have to say. And we still have 2, maybe 3 things to get. So
Yikes.
that's that time of year. So we're going to move on to S47, which is not in our possession, but it is something that we need to weigh in on because some constitutional issues have been raised. And is Katie going to run through this at all, or are we just?
I think she was planning on being here at 1:30 to do that.
So we have.
I'm not as familiar.
Right, she was going to give us kind of the background on the bill. All right, in that case, we'll just let me explain what's going on as far as our calendar for next week, since we have a few minutes before Katie gets here. And you could text her just to tell her that we're ready. I think that she didn't have things going on, but so S89. We're not going to be doing as much work early in the week on that because after a meeting with the speaker and the chairs of healthcare and human services, really decided that they needed to really take a good look at that. We're not going to lose possession of the bill, but it's going to be looked at by those committees, and they're going to get back to us towards the end of the week, and then we will. Given their input on that, we will move ahead with that bill. The plan is still to get that one out, but it's going to, I'm hoping that we get it over to the Senate in time for them to to address it. I think we will because it's an important bill for them. And I think that gives us a little leeway to send it over, even if the warning committees have closed by the time we get it over there. But we do, it's a bill that has lots of different parts to it that lots of different committees need to weigh in on. And before we do anything else, besides fix this one section that we're trying to fix, Section 7, we're going to get some input from some other committees. So there's that one. So we'll be spending most of our time on S4.
Oh,
And we're going to start. We're going to start a little earlier next week. I'm planning on starting at 8:30 because I don't know how long floor is going, and we have quite a bit of work still to get done. S6, we're going to look at a new version. I think we're aiming for Wednesday afternoon. Hopefully, we don't have a long floor time, and we'll fit in S33 here and there. Including possibly this afternoon if everything gets done more quickly. I've asked Michelle if she's available to go over another small bit of language that we might put in to the bill. And finally, that's a miscellaneous. Sorry. And S91, that Erica's going to be in this afternoon after S47 to give us a walkthrough of the latest language. I've distributed that language to state's attorneys and DMH and to the Matt Valerio at the Defender General's office. I haven't heard back from Matt, but the others, my understanding, are fine with it. Don't feel they need any further testimony. But I do want everybody to get a chance to look at it. We can have a little committee discussion and vote that out on Tuesday. Tuesday morning, I'm planning on meeting at 9, and it will either be to vote out or talk about and vote out 91, or looking at H89, which is on the notice calendar, will be up for action on Tuesday. And we need to weigh in on the amendments that were made, which we actually saw the language that we're going to look at in S37 that we just looked at the last couple of days. It's just to clue those up in the definition sections. So that should be pretty quick, but we do need a straw poll to move that along. So that's kind of the game plan to try to get all these things out in the next week and a half. So we're all set. Katie, thank you. That was perfect timing. I was able to kind of go over what the plans are for next week, and appreciate you running over here and giving us an overview. And so just to set this up really quickly, our role is relatively narrow, I think, but very important, looking at the constitutional issue. And really, when it comes to the Fourth Amendment issue, we'll really be leaning on Ben and his expertise in that area. But Katie's going to give us a walkthrough of what this bill is about at kind of a higher level and the other issues, so we know the context of the question. So thank you, Katie.
Welcome. Trying to log into your Zoom so I can share my screen. It's not very cooperative. Let's see. Meeting.
We've been having technical issues today.
So I've heard.
I think the whole building.
Yeah. And we're not even on ADS because I heard that they're having issues.
right.
Came from Washington, that's the problem.
Oh, Washington.
Read your emails. He's updating us, whatever his name.
Kevin Moore.
Yeah, he's been updating it. But I think it's all back in line. Probably have to redo everything.
Okay, success. So, Katie McLeod, Office of Legislative Counsel. Today we're going to look at S47, which talks about transporting individuals who are potentially in mental health crisis and need to be transported for an evaluation to determine if they need further assessment to be held at a hospital for commitment. When I was here a couple weeks ago to talk about the forensic facility, I had a chart pulled up. And it had lots of arrows of different ways to come into the mental health system, When I was here, we talked about the forensic arrow, people coming in through the criminal justice system. Today, we're talking about a different arrow. So under the current system, typically, under the current system, typically if it's felt that a person is in mental health crisis, a physician will do an assessment to determine if the person needs a further assessment by a psychiatrist. Sometimes that physician assessment is not available, in which case there could be an application to a court for a warrant to take temporary custody of the person and bring that person to potentially a hospital to have the psychiatrist do that evaluation and determine if the person should be held longer. So that's what the first section in S47 is about. It's about that warrant avenue into the facility, if that makes sense. I know that this bill was informally referred here on sort of a narrow issue. The issue that you're looking at is in section 1. The issue is a Fourth Amendment search and seizure issue. I can tell you what the second section is about, but I don't think that's where you're focused. That deals with transporting individuals who are already in the custody of the Commissioner of Mental Health, whereas the first section is dealing with somebody who's not yet formally the Commissioner of Mental Health, and the process by which they would come into temporary custody of the Commissioner of Mental Health while it's determined if the commissioner should apply for commitment of that individual. So that said, let me see if I can.
Katie, is there an age range with this? Could it be somebody under 21 or 18 or whatever age we're?
That's an interesting question. I'm going to get back to you. This section doesn't specify an age, but we do have language about commitment of individuals of certain age, and I don't know how the two interact. So I will look and I will get an answer for you.
Thank you.
Okay. Okay. You have the language?
Yep.
Success. Okay. So here's the first section in question. And I'll read you the first section, even though we're not making a lot of substantive changes here, just so you have a sense of what the warrant does. So in an emergency circumstance where certification by a licensed physician is not available without serious and unreasonable delay, that's what we talked about, that the most common avenue is with that physician, but the physician isn't available. And when personal observation of the conduct of a person constitutes reasonable grounds to believe that the person is a person in need of treatment, the person presents an immediate risk of serious injury to self or others if not restrained, a law enforcement officer or mental health professional may make an application not accompanied by the physician certificate to any superior judge for a warrant for an emergency exam.
So this is, which version is this? Because I think we're looking at the as passed by Senate.
I have 2.1. This is the version that's being looked at upstairs at the
All right.
moment.
Okay, well, that's
Subject
fine.
to change, of course.
Let me see if
But that part was
you
still
can-
on.
I can send it.
if you'd send it to Panina, she can post it.
What you just read was still just on as what was passed by Senate, wasn't it?
That was.
I mean, I was following you.
Yeah, but we were getting into that yellow where it looked like that was updated from past.
Okay. So that was subsection A. So we don't have a lot of substantive changes in subsection A. Our substantive changes come in subsection B. So right now, the existing statute authorizes a law enforcement officer or a mental health professional to take a person into temporary custody. This bill would change that so that only a law enforcement officer would take a person into temporary custody. And then once the person is in temporary custody, the law enforcement officer or a mental health professional is to apply to the court for a warrant without delay while the person is in temporary custody. Once that warrant process has been initiated, Either the law enforcement officer or the mental health professional, if it's clinically appropriate to do so, may transport the person to a hospital, police barracks, or another safe location. Then we have language that once the transport of the person has concluded, the law enforcement officer or the mental health professional who applied to the court for the warrant shall ensure that the warrant process is complete. So there has to be follow-up after the fact to ensure that the warrant process has been followed through to the conclusion. And then in subdivision 2, we have language about the transport. So the transports conducted pursuant to this subsection shall be provided to individuals with the same protections as provided to individuals in the custody of the commissioner or transported pursuant to 7511. That's the next section of the bill. So we'll look at what this cross-reference means. In section C, this is existing law. We're not making many substantive changes here. If the judge is satisfied that the physician's certificate is not available without serious and unreasonable delay, and that probable cause exists to believe that the person is in need of an emergency exam, the judge may order the person to submit to an evaluation by a licensed physician for that purpose. So we're having an assessment. That person is being assessed to determine if they could potentially be a person in need of treatment. That's a term of art in statute. And then the commissioner, the next step would be an emergency exam by a psychiatrist. Pending the results of that, potentially an application for involuntary commitment at the hospital. In subsection D, if necessary, the court may order the law enforcement officer, note not the mental health professional, to transport the person to the hospital for an evaluation by a licensed physician to determine if the person should be certified for an emergency exam. Transports conducted to this subsection shall provide individuals with the same protections to individuals in the custody of the commissioner who transported pursuant to 7511. Again, same cross-reference. And then in subsection E, mostly existing language, a person who's been transported pursuant to D, the section we just looked at, shall be evaluated as soon as possible after arrival at the hospital. If after the evaluation, the licensed physician determines that the person is a person in need of treatment, the licensed physician shall issue an initial certification that sets forth the facts and circumstances constituting the need for an emergency examination and showing that the person is a person in need of treatment. Once the licensed physician has issued an initial certificate, the person shall be held for an emergency exam. That's the second certification, that's the psychiatrist, in accordance with 7508. If the licensed physician does not certify that the person is in need of treatment, the licensed physician shall immediately discharge the person and cause the person to be returned from the place which the person was taken or to such place as the person reasonably directs. So now, to get to the piece about what are we cross-referencing with regard to transportation, they said this language applies to people who are in the custody of the commissioner. The commissioner shall ensure that all reasonable and appropriate measures consistent with public safety are made to transport or escort a person subject to this chapter to and from any inpatient setting under the jurisdiction of the commissioner in a manner that prevents physical and psychological trauma, respects the privacy of the individual, and represents the least restrictive means necessary for the safety of the patient. The commissioner shall have the authority to designate the professionals or law enforcement officers who may authorize the method of transport of patients under the commissioner's care and custody. And then under subsection C, when a professional or law enforcement officer is designated pursuant to the previous subsection, decides that an individual is in need of a secure transport with mechanical restraints, the reasons for such a determination shall be documented in writing. And here is, we have the change. It is the policy of the state of Vermont that mechanical restraints are not routinely used on persons subject to the chapter unless circumstances dictate that such methods are necessary. Law enforcement officer vehicle shall have soft restraints available for use as a first option, and mechanical restraints shall not be used as a substitute for soft restraints if the soft restraints are otherwise deemed adequate for safety. So that's the language that's being cross-reference with regard to how people should be transported. So, as I said, I think the section that you're probably most focused on in this committee is section 1. Healthcare was receiving testimony upstairs on this bill, and a witness brought up a concern that both the bill and the underlying statute with the warrant process was a potential Fourth Amendment violation. And as I am not your expert on the Fourth Amendment search and seizure, Ben has looked into this issue and can provide an analysis on that.
Great, I appreciate that. And did you email that version to Panina?
I did.
Okay.
Did you get it? Okay, I will check again when I
Yeah,
switch with
yeah,
Ben.
email's been weird.
It has been, yeah.
Yeah, Barbara.
So I'm assuming, because I know that there's transport that happens by law enforcement now. So I'm assuming in these cases, it sounds like it's only from an emergency room or department, right? Like that seems like that's spelled out.
So there's language about potentially somebody being transported to a police barracks. And there was a question about that upstairs, and the providers were in a better position than I am to explain in what situation it might be more appropriate to bring somebody to a police barracks.
And we did hear about people coming to police barracks related to the hospital bill. But I'm talking about removal from, like we're talking about not somebody's house, but from an emergency room to either the police barracks or another facility to be evaluated.
Not necessarily. This could be somebody is in crisis at their house.
Okay.
And assistance is called. There's an observation that that person is potentially in crisis. There's not a physician available, and the persons who are there seek a warrant to transport the person for the assessment.
So it's not so I'm assuming it's not voluntary. If I said to the person I was transporting them, are you interested in coming? We wouldn't need a warrant, right? Or we would get a warrant either way.
Better question for the providers, but this is an involuntary process. I don't know what happens if they just ask somebody, will you come to get an assessment, what process they follow. But this is designed for people who don't want to take that step to get the assessment, yeah.
And I'm assuming the documentation needed for choosing mechanical restraints over soft restraints is independent of the warrant, right? Like is the justification requesting in the warrant to use?
It's independent. So this is an independent evaluation about the person's condition, how they're how they're manifesting, how their mental health crisis is manifesting, and what level of restraint they need.
So that led me to think of something else, and I'm not sure if it's you or Ben or neither of you, but there was an issue a few years ago of youth who were being transported with mechanical.
Was this in relation to mental health crisis, or?
I'm not remembering if it's mental health or criminal justice.
Yeah.
But not you, probably.
This is the statute that would govern for an individual in mental health crisis. So I don't, without knowing more, I'm not sure I can answer that.
All right. And again, you were going to check and see because I know that there was a lot of discussion about youth being in mechanical restraints. Mm-hmm. And sometimes I think it was for just transport, not even. Yeah. So I'll be curious about the age range for this.
Mm-hmm. Okay, I'll clarify.
Thank you very much.
Minors are transported under this. I guess is yes, but I will defer to their expertise.
Angela.
I kind of, for whatever reason, zeroed in on that same section or subsection C on page 3.
Working it out too much.
And it just made me wonder, do you know, does it say anywhere else in, like, in 18 VSA, like, what, it says for reasons, the reasons for such determination shall be documented in writing regarding the need for mechanical restraints. And it just made me wonder, documented for what purpose, shared with whom, is this for like review purposes?
I don't think it's addressed anywhere else in Title 18. So a good question for providers or the department.
Okay, thank you.
It was always documented on the transport order. We got them in the request.
And then,
It's part of the, just all the documentation that goes with the case.
All right, I think that's good. Okay, thank you very much for that. And I think that Nina has gotten it right, and it's just been,
Still haven't, okay, I'll double check. Let me stop
yeah,
sharing.
because I think I kind of want the latest version.
Can we go to the healthcare committee's website?
No, that's why I just checked. Yeah, I just checked. Yeah, which version, just the as passed. But that may not. So while we're waiting to get 2.1 and if you even wants a printed out copy once you get it as well, we'll get a general overview of Fourth Amendment jurisprudence first, or do we need to have that bill in front of us before? Are you going to give us a general education first, or are you going to do it in context of the bill specifically?
In context of the bill and the current statute.
So you may have to just wait a moment because that language looks fairly different from as passed by the Senate. At least there seem to be a lot of
There have
yellow.
been changes, yes.
Yeah, so
Yes.
why don't we take a 10-minute break?
I mean, Phil, I should say that, the portion that I feel is really subject to the Fourth Amendment analysis probably doesn't involve a lot of the changes that are being made. It's
Okay.
really in my view, outlined in subsection A. I think the rest are sort of policy considerations about
All right.
who should transport and to where.
Okay. All right. Yeah, and we're getting away. But yeah, if it's subsection A, that hasn't changed so much. So, all right, proceed then. Thank you.
So most of my comments are encapsulated in the memo that's posted on the committee webpage. So I'll basically just be reflecting on those. But for the record, Ben Novogrodsky from the Office of Legislative Counsel. From a Fourth Amendment analysis, it's likely that S47 and 18 VSA section 7505 are likely constitutional. The specific issue is whether section 7505 provides constitutionally adequate due process to seize a person experiencing a mental health crisis for an emergency examination. So currently under 7505, a law enforcement or mental health professional may apply to a court for a warrant for an emergency examination when 1, a certification by a licensed physician is not available without serious and unreasonable delay. 2, personal observation of the conduct of a person constitutes reasonable grounds to believe that the person is in need of treatment. And 3, the person presents an immediate risk of serious injury to self or others if not restrained. S47, among other things, proposes to amend the statute and only permit a law enforcement officer to take the person into temporary custody and have the officer or a mental health professional apply to the court for a warrant without delay while the person is in temporary custody. A judge may order that the person submit to a medical evaluation after making a finding that the certificate was not available without serious and unreasonable delay and that probable cause exists to believe that the person is in need of an emergency examination. So the Fourth Amendment protects against unreasonable searches and seizures, whether the seizure is for law enforcement purposes or due to an individual's mental illness. A warrantless seizure for the purposes of involuntary hospitalization may be made only upon probable cause. That is, only if reasonable grounds exist for believing that the person sees is dangerous to self or others. The Fourth Amendment requires a probability or substantial chance of dangerous behavior, not an actual showing of that behavior. To determine whether probable cause existed to justify a mental health seizure, courts must look to the specific observations and information available at the time of the seizure. So here, both S47 and Section 7505 provide those type of protections under the Fourth Amendment. S47 and subsection A of 7505 explicitly require personal observation of a person constituting reasonable grounds that the person is in need of treatment. And that is in line with the Second Circuit's Fourth Amendment requirement that there be, quote, specific observations and information at the time of seizure. S47 and Section 7505A further require that the person pose an immediate risk of serious injury, which satisfies the Fourth Amendment requirement that a probability or substantial chance of dangerous behavior, or probability of a substantial chance of dangerous behavior, not an actual showing of such behavior, be present. Indeed, you could argue that the statutory and bill language both exceed the constitutional floor because an immediate risk of serious injury appears to be more exacting than a mere probability or substantial chance of dangerous behavior. Moreover, the statute and bill require that a warrant bookend any seizure upon a court's finding of probable cause, which again may exceed the constitutional floor of a warrantless seizure of a person for involuntary hospitalization. And finally, these requirements all take place only if a certificate is unavailable, which provides another form of protection. So the plain language of both the statute and the proposed bill are likely to pass constitutional muster under a Fourth Amendment analysis. Excuse me for me stumbling over my words.
No, that's fine.
Everything on Friday afternoons.
Hi, Barbara.
So I'm feeling a little confused, because we just passed out a bill that allowed us to have law enforcement be able to arrest somebody and transport them. And I guess I'm just trying to make sure I understood. Are we now saying if they're getting transported, the glitch that happened upstairs was we found out that we can't transport them without a warrant? And so now we're adding a warrant? Because if that's the case.
In this bill or in the other bill? I'm not familiar with the other bill.
Okay. So I guess it's different circumstances, but why did we just pass what we did? I mean, like, in just hearing you read that, I'm like, did we just pass something where we're going to have law enforcement transporting somebody possibly to the barracks or to another place without a warrant?
No,
Okay.
we did not. Yes. I mean, so.
Checking my reality here.
So we do have the Rule 3 exceptions, but they have to still have probable causes.
Well, the other scenario was for a criminal issue only, and this is for a mental health crisis.
That as well.
Okay.
Right. That's the more distinguishing difference.
Okay.
There are warrant exceptions,
Right.
like in exigent circumstances. But as Representative Oliver, this appears to be, from my perspective, a different circumstance than this other bill.
Just feels like a close cousin. And it's like, okay, this just wanting to make sure, because it's great that all these protections are being put in place.
There's sort of an exception in this in that you can take them and then get the authorization after it's in.
Right.
But it's for a mental health thing, not criminal justice thing.
And to that point, though, I mean, yes, the warrant is meant to sort of bookend this whole process when basically the circumstances dictate an emergency examination, essentially. But when you read the plain language of that subsection A, it essentially mirrors the probable cause language that's in the case law, and that would end up supporting the warrant issued by the court, because it says in the statute that probable cause must exist for the warrant to be issued, and that reasonable grounds to believe that language based on personal observations are all part of that probable cause analysis.
So then I think I have a question that's not for you, but probably for witnesses of when law enforcement is the transporter because somebody is in a mental health crisis. It's the same question we asked earlier. It's like, is that escalating the situation, and are there other neutral, and not that law enforcement isn't neutral, so that's not the right word, but possible, and I don't, trigger doesn't seem like the right word
That's
either.
intimidating.
Right, thank you. SSTA, I'm sure they love to do these kind of transport, but that, so it's not a question for you.
Yeah, these are involuntary folks as well. So, yeah, I just want to make sure I understand this. So you're suggesting that it's not a Fourth Amendment violation, even if we didn't have the last part that the law enforcement officer or mental health professional is to make an application for a warrant? Or is that part critical that for this not being a violation of Fourth Amendment?
Well, I would say that sort of is almost an extra protection in a sense, but you sort of need the same standard to seize someone involuntarily as you would need for the warrant itself. You need essentially those reasonable grounds to believe, which is part of that probable cause that you would need to ultimately issue the warrant. But this provides you, as long as it meets those requirements within subsection A, to see someone without the warrant first.
It is a critical, and you didn't go over it now that we have the new language. On page 1, starting on line 2021, is it important that the law enforcement officer is supposed to, without delay, apply for a warrant while the person's in temporary custody? I mean, is that kind of part of the saving grace of this, that it's not Fourth Amendment violation?
I think it's reasonable to infer that from this because, again, that's, I think, going to complete the due process analysis, is that they need to obtain this warrant really to justify any prolonged seizure of this person. This is really just if there's a temporary custody is repeated through this, and if those reasonable grounds exist to seize that person temporarily, in order to seize them any longer, you need to start and complete that warrant process. So I think it's sort of a bookend of the whole process to really ensure that it does maintain constitutionality.
So if you're only having them in temporary custody, you don't necessarily need the warrant, but we have the extra protection here by requiring a warrant. Is that what the case law would provide? I'm trying to.
Well, so there's not a lot of case law on this particular issue in Vermont. Most of it's within the Second Circuit.
Right.
And most of it is involving, for this particular issue of seizing someone involuntarily for an examination. And in New York, there's a case that makes a distinction, or really it's a footnote, that there's, under their laws, the mental hygiene law, which kind of dictates this process. But just because the statute itself might reflect a lot of constitutional aspects, it's not really the end all be all, because the statute, again, can kind of go above and beyond that constitutional floor. So they're almost separate analyses, but based on, this analysis, the way the statute is written, it really incorporates a lot of the constitutional requirements of reasonable grounds leading to probable cause, and ultimately the issuance of the warrant. And again, it goes above and beyond almost, and I think you could argue it, is that it doesn't require those actual behaviors to be observed, just a substantial chance from a constitutional perspective. And the statute here requires an immediate risk of self-injury. So it's almost it's a higher standard that has to be observed in the statute. So again, I think that further buttresses the statute's constitutionality, and that's not changed in S47.
I guess I'm still trying. No, that's good, but I'm still trying to understand. So the standards are met as far as the observation of the conduct. They're immediate risk of serious injury, et cetera. And that, the constitutional floor there is you could take the person into temporary custody. Is that just what?
It's not referred to as temporary custody, I mean, just seizing a person because of a,
But that's what that is though, right? I mean,
yeah, I think that's a way that you could refer to it.
so I guess then the question, right, okay, so let's say seizing the person, and there's no kind of time frame on how long you can have seized that person before you need a warrant?
Not in the statute. I'd have to do research, but there are restrictions on the length of time that you can detain people without a warrant. But again, that depends on the situation. It depends on what's observed. But I would have to do some more research and get back to you on what.
I'm just trying to, yeah, I mean, well, here it says without delay. I'm not as concerned. I'm just trying to parse out where those borders are with that. I did have one other question. I'll open up and see if anybody else has questions. So my understanding is, and correct me if I'm wrong, that Vermont's constitution has stricter standards generally for searches and seizures. Do we not, or am I misremembering which provision? We don't necessarily stop at what the.
So that would be Article 11, and the court has opined that in certain circumstances, it does have a higher standard than the Fourth Amendment counterpart. It is not, I haven't found Vermont Supreme Court case law on the specific issue. So whether or not this offers, the Vermont Constitution offers enhanced protections in this circumstance, I can't say currently. It doesn't mean that, there isn't necessarily an argument for it.
Okay.
But yes, in certain circumstances, Article 11 is more protective than the Fourth Amendment counterpart.
All right. Other questions? Joe, and then Angela.
I have a question regarding the procedure outlined here. So sort of piggybacks a little bit on what Martin was talking about. So if I'm understanding correctly, there is an observation of certain criteria that occurs. And if the law enforcement officer observes those particular criteria and this physician is not available to do this thing, they can take the person into temporary custody. So my first question is what is temporary custody in comparison to custody? Is it just that there's a timeline, or is there anything different about what you can do when someone's in temporary custody?
Well, I think you have to look at it in the context of this bill. So temporary custody is really until you can either get a warrant or until, they can be medically examined.
Okay.
So in this context, I think that's the interpretation of it.
So it's an arrest, but it's a temporary arrest.
Yeah, they're not free to leave.
Yeah. Okay, cool. And then the law enforcement officer or the mental health professional has to apply to the court for a warrant without delay while in temporary custody. And my question there is, how hard is it to apply for a warrant? Because I noticed in the next line that no transport can occur until the warrant process is initiated. Is it simply they call on the phone? I just don't know how that works.
Yeah, that may be a better question for law enforcement in that situation.
Cool. I will ask there. I also just wanted to confirm, do you know when this statute, the underlying statute, was originally?
It's been on the books, I want to say, for a few decades. There's case law going back to 1980 where it's referenced.
And there's no Vermont cases on this?
Not on the due process issue. Not that I found, at least.
Okay. Cool. Well, thank you.
Angela.
So this is just it might be a question for Katie. In page 1, B1, so I've noticed that mental health professional is taken out of those who may take temporary custody, but they're still process-wise able to do all the rest of apply for seek the temporary order.
So they could transfer the person, but the policy committee's added language that says only if it's clinically appropriate to do so. So the testimony that the committees have heard is sometimes the mental health professional doesn't feel that they're the appropriate person or that it's not clinically appropriate for them to be the persons transporting the individual. So that's why that change was made. And what was the second question?
I think that was it. I was just, obviously noticed that it was struck from that first sentence, like, so I was trying to just understand maybe process wise, making sure that they would, yes, then they apply to the court for a warrant. I guess I'm trying to picture this all happening and who's all involved and who's doing the observing. And yeah, I don't know. I think I need like the scene set to feel like I really understand the situation that a person might be in when this is all happening to them.
You have some providers in the room who would probably answer those questions for you.
Yeah, thank you.
All right. So we'll move to that.
May I ask just a quick?
Oh, I'm sorry. I didn't see your hand. Go, please, go
I
ahead.
might be bringing it way down here, though. But just, so this was to check about if this was constitutional by the United States Constitution, but then I heard that the Vermont Constitution might have a higher bar. So is this assessed at that level at all, if it meets Vermont?
I haven't found any case law that speaks to that
We
issue.
can't determine that as well. Okay.
Not that I've found.
Okay. And then my other thing is, like, I really appreciate all this. This makes sense. It's all the points, and here's why it meets it for me. My thing is the qualifier, the modifier of are likely to pass constitutional muster. Like, is there a spectrum? Like, where is likely to pass versus strongly will? You know what I mean? Or is it all the
That's the
same?
old law school mantra, if it depends.
Okay. I'm like, that sounds good to me, but I'm like, is that way down here? Or?
And the reason, that it was phrased that way is that it could also be situationally dependent, and facts will largely dictate how the statute and this bill, if it's passed, is actually implemented. So I guess that's sort of the qualifier there, is that on its face, it appears constitutional, but there might be a circumstance where someone's seized and reasonable grounds don't exist and it has to be litigated in a court.
Okay, thank you.
Right. Thank you very much, Ben. Then we'll hear from Karen Curley next. Did I pronounce that right?
Actually,
You did.
I think we wanted to go with you first.
Oh, okay. All right. Please do. Yeah, that's absolutely fine. I didn't get the order right.
Although Karen does have a time constraint, so I may
Kristen,
interrupt.
hi, everyone.
Yes, Karen.
Kristen, you go right ahead and start. I think Dylan maybe has a little PowerPoint to go along with Kristen's portion. And then I'm going to follow you, Kristen. And I've already let my 2:30 know that I might be some minutes late. So we're okay.
All
Thank
right.
you.
Thank you. So Kristen, identify yourself for the record.
I'm Kristen Chandler. I'm the coordinator of Team 2, which is a statewide training for law enforcement, mental health clinicians, and other first responders. It's a grant administered by Vermont Care Partners, and I subcontract with them, and I'm here in that capacity. I do. Yeah. You coming? Excellent. Look forward to it. I'm going to share my screen.
So Panina is yep, you're getting post in 1 second.
So I just, right off the bat, I can just answer a couple of questions. This statute applies to kids and adults. We try not to take kids into custody and mental health warrants, but it happens. Am I good to go now? Okay, super. So I just want to let you know, if you're not familiar with Vermont Care Partners, it's sort of the trade association that oversees all the designated mental health agencies in the state, as well as the agencies that represent people with intellectual disabilities. And they hold the grant that is a collaborative grant between the Department of Mental Health and the Department of Public Safety that runs my program, which is the statewide police training for first responders. And so this statute has been on the books for over 50 years. And it has never changed, the mental health warrant statute. And the whole point of a mental health warrant is to get somebody some help, to get them to a doctor. It is the last resort in voluntary care. And the process, the way it works is a QMHP or a qualified mental health professional who is deemed so by the Department of Mental Health and gets recertified every 2 years. They are generally the person who starts this process. It could be law enforcement, but almost all the time it's a QMHP who is actually doing that assessment, whether it's in the field, it might be over the phone, it might be in an emergency department, it could be anywhere. But most often, if possible, it happens in the field. Kind of a little bit depends on what county you're in Vermont about the resources that are available, but this is a real team of responding these days to mental health calls. It's a real team approach between law enforcement and mental health crisis clinicians. So we've noticed over the last few years there's been some real hiccups in the statute itself, especially when the use of force policy passed. It really changed the way law enforcement were responding to mental health calls, and so Vermont Care Partners got together with a group of stakeholders to come together for a 6-month period and talk about how we can change the statute to really fit the reality of the work and the logistics of the work. So we really just wanted to clean up language. We're not changing anybody's rights. We're not asking law enforcement to do anything more. We're not asking the Judiciary, the Department of Mental Health to do anything more than they have been doing over the last 50 years that the statute's been in effect. One of the things as a result of the statute not sort of fitting the practice, what has happened is there have been a couple of situations, more than a couple, where there have been real delays for people to get care. When you keep in mind the purpose of this statute is to get people some help when a physician is not available. So this is where if somebody is in crisis and somebody has called for help, the statutes, the laws that we already have in Title 18 dictate that we use the least restrictive method possible to get that person some help. And so they're always offered first a voluntary, are you willing to go to the hospital? If they're at that level where they need to go see a doctor, if they go voluntarily, that's great. And that means either on their own or with a family or somebody who's going to transport them. It's these people who fall into a different category, where people who say, no, I'm not going, and refuse to go, and they are clearly a danger to themselves or others, as deemed by the QMHP. But then they try all their tricks in their bag to try to get somebody to go on their own, and they won't. Then they have to write a warrant. It's really a transport ticket almost. And once that decision's been made to write the warrant, that's when law enforcement can then take somebody into temporary custody and hang on to them while the warrant is being applied for. And that's what happens all across the state right now. And while that law enforcement officer is hanging on to that person, they're taking them to the emergency department. We're asking them to take them to the emergency department, and most of them are taking them there. Occasionally, they're taking them to a police barracks or some other secure location, depending on what's going on. And meanwhile, the QMHP is writing the warrant and trying to get in touch with the judge. And the logistics of that process really depends on the time of day that this crisis has happened. If it's during the daytime, they're contacting the judges who are on the bench and doing other things and having to wait for them to take a break or whatever, depending on the county that you're in. There may only be one judge. If it's at night, there are judges who are on call. And so that is happening over the phone most of the time. Judges have been educated over the last few years to remind them that this is, the whole point of this is to get somebody some help. And so we've sort of nipped in the bud a few parent cases where judges have insisted people come in person to them, get sworn in, all this stuff. It's just a delay in care. And so most of these are happening over the phone. And it's either the law enforcement officer or the QMHP who's making the contact with the judge, reading them their affidavit, which is signed under penalty of perjury, I will say, and then getting the go-ahead and have a doctor examine this person. And meanwhile, the person is where they need to be, which is in an emergency department where the doctor is going to be.
Before you go on, Joe.
Just a clarification question, since you're talking about this right now. The statute or the bill as written says that They'll apply for the warrant without delay while they're in temporary custody, and then once the warrant process is initiated, then the transport happens. And so this where it goes back to my question from a few minutes ago. What does it mean to apply for a warrant and a warrant process to be initiated?
Yeah.
What, and how,
Yeah, sure. That's a great question. That's that decision where the QMHP, they have to make their decision based on, first of all, does this person have a major mental illness? And second of all, are they a danger to themselves or others? Or is this behavior caused by some other thing that's going on? You know, so many people have dual diagnosis. They're really the professional to sort of tease that out. And then, so once that's the critical point of when that decision has been made, that then the officers take it, they're saying, yep, I'm gonna need to write a warrant. The officer takes the person into custody and transports them. What I just want to back up a little bit, the stakeholder group that Vermont Care Partners put together involved lots of different people, people with lived experience. Mad Freedom was there, Mental Health Law Project. Jack, both your witnesses, the other witnesses today were present and able to participate in all of those meetings. Again, all the stakeholders you might imagine had a chance to weigh in. And this is what we came up with to try to fix some of the issues. One was we're finding that sometimes in the field, officers are looking at the statute and saying, well, it says QMHP, you can take them into custody and you can transport them. So go ahead. And the mental health clinicians were like, we're not equipped to do that. We're not trained in how to take people into custody and we don't want to. But the officers, there would be some places where they'd be arguing on the side of the road, up down the scene. Pointing fingers, and it was really not helpful because despite our best efforts in collaborative work, there are still some pockets in the state where there's a little bit of tension there about whose responsibility is this. No, I'll tell you that people, this is a really big deal to QMHPs to write a warrant. They understand it is taking somebody's liberty away, even for just a 72-hour period. It's a really big deal to them, and it is the last resort. And it's time consuming. It takes a lot of time. It's not a very quick process at all. From the documentation itself is pretty thorough. And then it's the getting in touch with the judge, making sure it gets either emailed, encrypted email to the judge or read to them over the phone, excuse me, or somehow, in their hands. And usually what would happen is that if it's, let's say it's in the nighttime, and it's not like you're seeing the judge in person, you're on the phone with them, the judge will tell the QMHP how to sign the warrant. Either sign it, Judge Jones by Karen Curley, or sign your name as authorized by Judge Jones or whatever. So they work that out on the phone. So we really had what we thought was a really great process to get input from people, and what came out of that was our proposed changes to the statute. And then since we've been in the House Health Committee, we've heard a couple suggestions from the Mental Health Law Project. And these also came up during our stakeholder groups. One is to have an expiration to the warrant, which Vermont Care Partners does support. What we were dickering over was how much time that should be. We initially had proposed a 5-day expiration because of the logistics in some areas of the state of police actually serving the warrant. Mental Health Law Project suggested 72 hours. We're good with 72 hours. But we really do think there needs to be an expiration date. We have had some cases where the warrant, there are some situations where the person is not, they've fled. Okay, they may have been in somebody's office, they may have had a crisis, they've had that chance to personally observe them, a warrant has been applied for and granted, but the person is in the wind and not found for, in one case in particular, I can remember 20 days later, got pulled over for a traffic infraction, warrant still active in the system, person seemed perfectly fine. The officer was like, what am I going to do? Like, there is a warrant, and had to transport them against their will to the hospital. Doctor took one look at him and said, you're fine. People get better. It's not, that's why we have a requirement. As people are waiting in the hospital, they have to be seen every 24 hours by a clinician to make sure they still meet these requirements. So that's why we support an expiration period. Mental Health Law Project has proposed requiring an additional affidavit if the author of the warrant has not personally observed the behavior. And that we have a real problem with because oftentimes we don't want the QMHP to personally observe the behavior because it's too dangerous for them to do so. Most of the time they're getting that information from police or from family members. And they're distilling that into a warrant and they're signing that under pains and penalty of perjury. I have heard the Mental Health Law Project talk about 2 cases where information ended up in a warrant that wasn't backed up by personal observation. I think 2 cases in 40 years of doing this work doesn't merit requiring a whole new system where we have to write affidavits. And I think that Karen Curley is going to address the particular difficulties that would pose for QMHPs in having to track down people to get affidavits for that.
Barbara.
So, yeah, go right ahead. Was part of your stakeholder group folks from the network? Because I'm trying to think about situations where there's been domestic violence situations and.
I don't believe they were in this. No, they were not part of the.
Okay, just in terms of.
No, it was really mental health focused and people with lived experience.
Okay.
People who are actually doing the work or may be people like the Mental Health Law Project who may be affected by the work.
Right. I was just thinking in terms of when you said family members, because sometimes I know.
Well, NAMI was there.
Right. So, I'm assuming if there were only 2 cases within that time period, there weren't a lot of false accusations that sometimes it comes up related to custody battles for kids where somebody is.
The QMHPs are really good about sort of seeing through that.
That's great.
Yeah.
Okay, thanks.
We have a little bit of a joke that when moms call, they're not to be, you have to take that with a grain of salt a little bit because they're always pretty upset about what's happening with their loved one. But it's not, I mean, they're really good about teasing that out.
But, yeah, I was thinking, yeah.
So I have maybe more of a question for Katie or for Ben. Or you. So have these proposals gone to the Healthcare Committee?
Yes.
And I guess for Katie, do you know if they're asking for our opinion on those particular? Because I know that we've been asked about Fourth Amendment constitutionality, and I guess the question for Ben, there's going to be multiple questions at this point, because we'll start with this one. Do these issues, as far as the extra affidavit or expiration period, does that have any impact on the Fourth Amendment or constitutional analysis? It's kind of one question. I got 3 or 4 that I could throw and pile on right now, but I'll wait for.
I mean, I think, honestly, I think those are policy decisions because the current statute as is, by my analysis, is constitutional.
Right. But does this provide any additional protections that we should be concerned of here in Judiciary Committee? I'm just trying to parse out making sure that we're staying in our lane.
Mm-hmm.
Yeah, I mean, I think that those are additional protections that a committee could consider, but I would say that that's probably a policy consideration to provide more protections than what's constitutionally required.
So my understanding was that healthcare was anticipating this committee to provide an assessment as to whether the first section comported with the Fourth Amendment. And they said that they would continue looking at the policies behind having a expiration date on the warrant and which type of personal observation would be required, by whom, those types of issues.
Okay. Yeah, because I don't see the length of warrant issue necessarily in our committee. I don't want to step on their feet.
They said the same thing, actually, about when this constitutionality issue came up through a witness. They said the same thing about trying to stay in their lane.
Yeah, and
Which I think is why we had to come down here.
Yeah, no, and so if our lane is the Fourth Amendment, I need to understand and what I'm understanding is these issues of the length of time for the warrant, the expiration period, the extra affidavit aren't necessarily related to that, but then I'll broaden it and say, is that within our jurisdiction generally here in the weigh in on? And if they're punting to us and they're looking for us to weigh in on those specific questions,
I didn't hear them ask that.
Okay.
I really heard them ask about the constitutionality.
yeah. So this is helpful, but I don't think we're.
Well, I got to say, Mr. Chair, that I wondered the same thing, like, why am I here? But I don't think it hurts you to know about.
No, it was actually very helpful on the training and so because of all these other things we're doing.
Yeah.
It's just that I'm seeing, do I need to provide our viewpoint on these things to healthcare? And I don't think we do on these things.
And
I'm not saying that it was not good to actually hear this and get this context, and so.
It is Friday afternoon.
Right.
And I know that Karen Curley I don't know, do you still want to hear from Karen Curley about the issue about the affidavit, or?
I really don't think that that's our issue. Ben, whether there needs to be an extra affidavit for a warrant, maybe it is.
I mean, really, a warrant just needs those personal observations. If, there's an additional one, I would say that's probably duplicative of what's necessary.
Right.
Well, I think the personal observation issue could become a topic, an issue. So I'm going to suggest that you, because I think Karen's going to address that.
Okay, yeah. No,
I don't mind.
Yep, let's hear it. I appreciate it. Any other
questions?
Any other narrow questions for Kristen?
And I just want to be really clear from the questions I heard before. I think you were thinking about House 36, the arrest at a hospital.
Yeah.
This is
very
all
different.
in the field trying to get somebody to a hospital. Okay.
I appreciate it. So thank you. And we'll talk to Kristen. Karen next. We just talked to Kristen.
Do I just?
Friday afternoon.
Okay, sure.
That's all right.
There's, and you may want to take it off the shared screen so we can actually see Karen. Besides just a little, there we are. All right, thank you, Karen. If you can identify yourself for the record and proceed, I appreciate it.
Sure, absolutely. My name is Karen Curley, and I am the Intensive Care Service Director at Washington County Mental Health. I'm also a licensed psychologist, and I have practiced in community mental health crisis services for 25 years. And I have some examples that hopefully perhaps will be helpful to illustrate for the committee how this actually plays out in real life settings, if you will. As Kristen said, what I originally was here to talk about, which maybe I'll broaden a little bit, was related to our concerns. And I'm here representing, I'm also the chair of the Designated Agency Emergency Service Directors Group. So I'm also here representing them when I say we. And so we had some significant concerns about the additional layer that Vermont Legal Aid was suggesting related to the written and signed affidavits from witnesses. And that I'm going to tailor originally that's what I was, my scenarios were more about that, but my scenarios I think will still hopefully be helpful for you all. What I want to say about my scenarios is that my scenarios are based on some real events. However, I have cobbled them together in different ways and with some fabrication to ensure that people's personal privacy and rights are protected and their confidentiality. So let me also just say our concerns related to the potential of having to have written affidavits are related to it will slow down the process of getting a person to the treatment that they need, a person who is in a mental health crisis. It also is a safety concern for us in terms of delaying the process. And it also potentially could impede the collaborative process between the qualified mental health professional, who we refer to as the emergency screeners, and law enforcement. So here, I have 3 examples that I'll give really quickly for the committee that hopefully will be helpful. So there's a 50-year-old woman who's here in Vermont visiting her sister. The woman is diagnosed with bipolar disorder and is currently experiencing symptoms of mania, as evidenced by the fact that she thinks her sister is poisoning the water they're drinking. In the morning when they wake up, she gets agitated and upset with her sister, and she assaults her sister. The sister is able to get away and calls 911. Police respond. Police ask the mental health emergency screener to also respond. When the mental health emergency screener arrives on the scene, the woman is outside. She's agitated. She's pacing. She's talking to herself. The screener attempts to interact and engage with her, and the woman is unable and unwilling and unavailable to consent for transport to the hospital. So the screener knows we're the trained folks who look at, does the person have a diagnosable mental illness? Can I tie the behavioral presentation that I'm observing to that diagnosable mental illness? Is there a standard of dangerousness, of imminent risk to self or others? And are all other less restrictive or voluntary options not available? So we always offer, we want to provide voluntary treatment. We want people to get the help that they need in an expedient manner. And we also want to follow the steps that we need to follow to ensure safety for everyone. So then in that same situation, I go into the home as the screener, I talk to the sister. The sister is visibly distraught, as evidenced by she's crying, she's shaking, she's labored breathing, and I can see evidence of the assault that has happened. She has bruises, she has scratches. I talk with her, I ask her what has happened. She verbally tells me the story. If I then had to have that same sister write and sign an affidavit in addition to the rest of my steps of the process, that would absolutely delay it would delay the application process. It would delay access to care for the woman who is in mental health distress. The sister might choose that she doesn't want to sign the affidavit because she's concerned about maybe there is a criminal part of this, even though I've assured her that's not the case. And so she refuses to sign it. My personal observation is my interaction with the woman when I was engaging with her outside and when I come back outside and I again talk with her, but I did not personally observe the assault that happened. That is the sister who is. So what we do in our application process, just in terms of some of the steps so that the committee can hear some of the steps, is that what I will do is then I write out my warrant application. The police are ensuring that the scene is staying safe for everyone involved. And then I call a judge. I read my warrant application to the judge. Within my warrant application are listed the sister's name and contact information if anyone needs to contact her at a further date in any sort of proceedings, and also whomever the law enforcement entity is as well. And then, as Kristen said, then I sign it under penalties of perjury. So that's one example of a situation that absolutely could happen. Another example is a sister in Massachusetts calls 911 in Vermont to report that her 40-year-old brother is suicidal. He has a loaded gun. He's in a car at a rest stop on I-89. The sister calls 911, as I said. Police head to the scene. Police call mental health screeners to also head to the scene. Police, by the time the screener is able to arrive, police have safely taken the loaded gun from the individual. He has tried to run into traffic, so they have detained him for his safety. And he's sitting in the back of a cruiser. And I go, and as the screener, I go and I talk with him, and he tells me that life is not worth living. Nothing matters. He has nothing to live for. He has a diagnosis of depression. He's lost his job, and he's getting a divorce. He refuses to voluntarily be transported to the hospital. He says it doesn't matter anyway. no one cares about me, treatment doesn't matter, I'm not going. So now I know I'm in a place, I don't have access to a licensed physician, I'm in a place that I need to fill out the warrant application. What I will also say is that we prefer in the field, we recommend best practice is that the qualified mental health professional is writing that warrant application because of those criteria I said previously. Law enforcement and the mental health professional on these crisis scenes, we are very much trained about what our roles are and the steps that we need to go through. So I'll give one last quick example, which is there's a 28-year-old fellow who is in his family home. He's experiencing some symptoms of psychosis as evidenced by, he thinks that the government is monitoring his thoughts. He punches windows in his home. He needs medical attention, but he leaves the home. It's wintertime. He leaves in socks and without a coat. He then walks into the road. Traffic needs to stop to safely ensure that they don't hit him. The family can't see him any longer. They've called 911. Police are on their way. They ask us, mental health emergency screeners, to respond as well to the scene. When police roll up, there are multiple cars that are on the side of the road so that they did not hit the fellow. The fellow is trying to get into the car with those people because he's trying to get away from the government. There are children in one of the cars. So police need to detain him. Screeners, again, when we observe him, when we see him, he's in the police car. We talk with him. He, at that point in time, is unable to speak in a manner that we can understand what he's talking about. He's not providing consent to treatment. He's not providing consent to be transported to the hospital. He's agitated. He's trying to get out of the car. So it's clear to me I need to start the process of the warrant application. In any of these situations, if I have to figure out how to get a signed affidavit from the sister in Massachusetts or the family who's in that family home or the drivers on the side of the road, that will absolutely slow down the fellows or the people who are in mental health distress, their access to treatment. So we believe that we understand for legal aid why it is that they wanted to put in the extra protection related to the written signed affidavits for the individual's due process, but we also have grave concerns of the balance around ensuring that people who are in a mental health crisis and in distress can have access to treatment as expeditiously as possible. So we believe that the current practice pattern that we have related to the QIMP qualified mental health professional applying for the warrant, writing the names and numbers of witnesses who have different parts of the personal observation, and the police helping us to secure these scenes. Because again, in all of these scenes, the level of dangerousness is of imminent risk to self or others. And so the risk would be that if law enforcement were not doing that, if they were not securing the scene, that further harm could happen to the individual or the people around them. So that is my testimony. Those are my examples. I hope that's helpful to you all in terms of how it plays out in the field. Thank you.
Yeah, no, that was actually very helpful. And maybe it has to do with what we have to weigh in on. You did mention a magic word of due process. We're going to probably hear more from Jack on that. We can expand beyond just the Fourth Amendment. But also very helpful because we're dealing with these issues a lot, and actually having some actual examples of what happens for our broader work has been nice. But a couple questions, Joe, then Tom.
Thank you so much for those examples. That was very helpful. I guess one thing that I'm trying to understand here is the observations that you are putting in your warrant application, are those entirely, I guess what I'm trying to ask, or anything, how to phrase this. So would you say, take your first example, the sister, whatever her name is, assaulted so-and-so. Or would you be saying, in your warrant application that I observed that the sister had a black eye, and that she was very agitated, and she told me that this had occurred, and I observed the sister who was pacing outside, and as someone who's trained in all these things, I observed that it meets these criteria. So I guess what I'm trying to get at with that question is that, is your warrant application always based entirely on your own personal observations, or does your warrant application say things that other people saw that you can't authenticate?
Absolutely. So it's a great question, and both is the answer. So absolutely, it's my own personal observations, exactly as you said, of how I have evidence. So I really try to speak very factually about what I can observe about the situation. And that's my personal observation. My personal observation is my interactions with the person who's in mental health crisis, as well as anybody else who has been affected by the circumstances. We also do include quotes from other people who have relayed the information to us around the circumstances that have led to dangerousness. And then we also put in our written warrant application the names and numbers of those individuals who have relayed that information to us. So we do all three of those things in the written warrant application.
This sort of might be a hard question to ask because it's really spinning hypotheticals at this point, but I'm just wondering, if, let's take scenario one again, let's say that all the facts of scenario one are the same, but you arrive and the sister who is alleged to assault the other sister is perfectly calm, rational, has a really rational conversation with you, and either denies that it happened or maybe says something that doesn't have to do with a mental health issue. Rather, she was really mad at her sister because her sister, I don't know, stole something, and so she punched her in the face. But the sister was assaulted, says, oh, my sister has bipolar disorder. This is just her acting due to her mental health crisis. Would you write a warrant in that situation?
It's a great question. So in that situation, if the person who's in mental health crisis is presenting very reasonably and de-escalated with me, I'm going to use my skills to try to convince them to go with me voluntarily. I'm going to try to separate the two individuals. I'm going to play that out longer to see if I can get voluntary options available. I think in terms of at the end of the day, would I apply for a warrant application in that hypothetical? I don't know. And here's why I don't know is because it would depend on so many further circumstances related to, do they re-escalate together? I need to make sure that the situation is going to be safe when we leave. And so I will take longer in that situation to assess and to try to figure out a safe disposition that is not a warrant application. But it is possible that, yes, I could decide to write a warrant application in that situation if I believe, again, those four criteria are being met of a diagnosable mental illness, of I can tie the behavior to that, and there is an imminent level of dangerousness to self or others, and there are no other voluntary options available. I don't know if I would write the warrant application in that situation because I would need to play it out more.
Yeah, I figured that would be part of your answer. I guess what I'm really trying to get at is, would you ever write a warrant application in a situation where you did not personally observe anything and you were relying entirely on what others told you had occurred?
No.
Great, thanks.
I would not.
Then Angela.
Hey there. I'm trying to boil it down into top thought, actually. What you've been talking about. I think we use some different terminology, so I'm just trying to lay it out in my brain. I heard mention of more than one affidavit. Are you referring to the time that it would take to get affidavits from other people that witnessed the behavior by just simply bypassing that and putting them inclusively into your warrant and your affidavit? thinking that once we have this, we can get the person treatment, and it's going to be obvious that they need the treatment so that we don't have to spend the time interviewing numerous people in depth and getting it in writing.
Correct. And let me I'll just quickly extrapolate a little bit on that. So the example I gave of the sister in Massachusetts, she's verbally given me her information, which is a part of my puzzle, right? It's only one piece. I have personally observed and interacted with the fellow, but the sister is the one who started off with the information related to his life circumstances. If I then needed to get that sister to write and sign a warrant, or excuse me, a affidavit, I have to figure out how to get that affidavit to her. I have to figure out how she's going to sign that affidavit. I have to figure out how that affidavit is getting back to me. And potentially, if I have to do all of that before that fella is transported from that rest stop, I in fact am delaying his access to care that he needs on a more immediate basis for his mental health crisis. So my understanding is that Vermont Legal Aid was requesting a requirement that we, rather than writing in our written warrant application, that we write the person's name and their contact information, that all witnesses would write their own affidavits and sign them. And we just believe really strongly that that will absolutely slow down the process of access to care for the individual.
So you're just going to try to rely in your affidavit on a reasonable interested party.
Correct.
Yeah. Okay.
Yep. So in my example of the family and the drivers on the side of the car, I would use my own personal observation with the fellow, my interview, my assessment that I've done with him. I then would talk to the family on the phone. I would get their information as collateral information. I then would I might do this in a different order. I might talk to the drivers first so they can go on their way. But I would talk to the drivers as well to get their information, and I would talk to law enforcement, and I write all of those names down and their contact information.
Perfect. Thank you.
Angela.
Thanks. So, thank you. I think my question, something Joe said, and then you answered. I might get back to it, but I think I remember that. I'm looking at the second in the bill, the second condition for seeking this warrant is when personal observation of the conduct of a person constitutes reasonable grounds to believe that the person is a person in need of treatment. And you've mentioned a different set of criteria, I think, that you use, and the first one is a diagnosable mental illness. So I'm wondering, in your practice, if you have not been informed that the person, coming into the situation, you don't have the sister who's saying, my sister has bipolar disorder, or, has been diagnosed with XYZ, are you diagnosing on the fly? Or is it just that you're just looking for the conduct that constitutes reasonable grounds to believe that the person is in need of treatment?
That's a great question. So what I'm trained through both the Department of Mental Health and my clinical training, and then in our agency, for example, I supervise the screeners, so they get clinical supervision from me. We are looking at doing an assessment of what's happening for a person's mental health. We then make what I would call a conditional diagnosis in the moment. So I don't necessarily have the same amount of time with the individual as somebody who's going to be their treating provider to make a definitive diagnosis. But in the moment, I can make a diagnosis related to the signs and symptoms that I'm seeing that then I can defend in a court of law to say, hey, how is it, Karen, that you came up with this provisional diagnosis of schizophrenia, for example, or bipolar disorder, or depression, or mood disorder? And then the onus is on me to let folks in that court process know why I came up with that as a diagnostic impression that I put on the warrant application.
And do you, as part of your training, is there a culturally responsive component Period, question mark, that's my question.
Absolutely. Yes, absolutely. So that is a great question. We absolutely, I'll speak for my own agency. It's mandatory that all employees have a cultural competence training. It's also required that those of us who are licensed continue to keep up our licensure. One of the ways we do that is through cultural competence trainings. We have it's professional responsibility that we consider cultural considerations in each setting, and through supervision trainings, that's required of us. That's standard good ethical practice.
Okay, good, thank you.
Yep.
Thank you very much, Karen. Really appreciate your time as well. And we're going to move on to Wilda White next. And Wilda, if you're there and hear me, join us. Good afternoon, Wilda. Nice to see you.
Thank you. Good afternoon to you as well. I will say at the outset that I am hard of hearing, so it's a little difficult for me to hear, but I wasn't able to travel to Montpelier today because of some pre-existing commitments, more local. So the Wilders out of AI are my live transcription. And so I might have to refer to the live transcription before I can answer your question. So there may be some slight delay.
Okay, no problem.
Okay.
So if you
I'll
can identify
introduce myself. Yes.
Yes, thank you.
Yes, my name is Wilda White. I am the founder of an organization called Mad Freedom, which is a human and civil rights advocacy organization whose mission is to end the oppression and discrimination against people based on their perceived mental state. I'm also an attorney. I'm licensed in New York, California, and Massachusetts. And for the majority of my practice, I was a plaintiff's civil trial lawyer. And a large part of my practice was civil rights litigation. And I also was the inaugural executive director of the Center for Social Justice at the University of California, Berkeley School of Law, where I taught law students who are interested in pursuing careers in public interest. I tell you that because I am that witness you've been hearing about who has challenged the constitutionality of the existing statute as it is applied in practice. And when I testified in House Healthcare about it, my constitutional challenges or concerns about the statute were not limited to the Fourth Amendment, but also expanded beyond to the Due Process Clause of the 14th Amendment and the Equal Protection Clause of the 14th Amendment. The Fourth Amendment does prohibit, kind of unreasonable searches and seizures without a warrant, prevents the government from doing that. But as you heard, there are exceptions to the warrant requirement. One of those is if a person has a mental illness and they're a danger to themselves or others, police officers or government authorities are allowed to detain somebody on an emergency basis. But there are limits on how that emergency detention can be affected. The limits are imposed by the Fourth Amendment itself, which requires that the danger be imminent. There are also constitutional safeguards, due process, 14th Amendment safeguards that says that you have to have notice and an opportunity to be heard. It has to be based on the Equal Protection Clause of the 14th Amendment says that it has to be based on specific and articulable facts that indicate an imminent danger to self or others. It can't be based on assumptions about just because a person has a mental illness. It can't be based on speculation because of a person has a mental illness. It can't be based on stereotypes based on people who have a mental illness. And there's also another requirement that these detentions they have to be based. You have to use the least restrictive alternatives. And so if we had more time, I would probably want to do this a little differently, but because we're ending the time and there are other witnesses, I will say that my concerns about S47, which is attempting to amend 18 VSA section 7505, are these. The first one is that in the current practice, people are being picked up based on no personal observation. So, for example, law enforcement officers report that they will receive a phone call from a mental health professional saying, "Hey, I'm going to write a warrant. Go pick up this person." Based on the statute and based on the constitutional requirements, it's our belief that that's unconstitutional because it has to be based on personal observation, and the law enforcement officer had no personal observation, and they also have no warrant. Also, the applications that form the basis of the warrant under current practices are also not totally based on personal observation. In fact, the application form that the Department of Mental Health uses says that, and I'm reading from that application, it says, state the facts you have gathered from one, either your own personal observations, or two, a reliable report to you by someone who personally observed the proposed patient's behavior that leads you to believe that the proposed patient is a person in need of treatment. I also think that runs afoul of the due process clause of the Constitution because it's not based on personal observation. It's not based on those specific and articulable facts from the person who observed that conduct. Also, I think that the way this is practiced currently is that it also violates someone's due process protections because when they're picked up, they're not told why they're being picked up. I had the opportunity to witness one of these, and it was just law enforcement officers going to the person's house, saying they had received a report, and taking the person into custody, and the person kept saying, "I'm being arrested," and they say, "Oh, no, you're not being arrested." And they're like, "Well, what's happening?" And they provided no explanation to the person, just that they, quote, had to do it. And then under current practices, people where there's no warrant been issued are being taken to the emergency room, even though they're not a patient, even though there's no warrant been written, even applied for yet, or maybe in the process. They're being taken to a hospital where they cannot be forcibly treated. And so I also think that violates the due process and the protection clauses of the 14th Amendment. The statute also, as written, doesn't provide, is ambiguous and doesn't really provide adequate notice to anybody who's subject to it. For example, it uses the term temporary custody without any definition, except that the word custody is defined in the list of definitions that apply in this subchapter. But the definition in the law is that custody means safekeeping, protection, charge, or care. That's not something that we typically associate with what law enforcement officers do. And the word custody is a very elastic term, and it can mean many things. And it's really unclear what it's meant in this statute, particularly because it's used to refer to temporary custody by a mental health professional, temporary custody by a law enforcement officer, and it also uses it in the section about temporary custody on behalf of the commissioner. The other word that I feel like is also very ambiguous, and who knows what it means, is that this process can only be implemented if getting a certificate from a licensed physician would, quote, result in serious and unreasonable delay. I have no idea what serious and unreasonable delay means. And I feel like anybody who's subjected to this term could never contest this statute because these terms are undefined and you'll never know what that means. So that's another of my problems with the law as currently practiced and some of that as currently written. I think the problems with the proposed amendment exacerbate some of these problems, because I think it attempts to clarify in an ambiguous way that it's okay not to have personal observation, because it says that I think you could be read to say that the law enforcement officer could just pick somebody up without having personally observed any observation, any behavior. I also think that the proposal to transport a person who has not been deemed eligible for an emergency examination yet, to be able to transport that person to a hospital who is not a patient, who cannot be treated by that hospital until they become a patient or until a warrant has been issued, to transport them to a hospital, I think violates their constitutional rights. And finally, I mean, this may not be, I will say that argument. I think there's some arguments that I will probably, that may be more appropriate in the House Healthcare Committee, but I'm concerned about the way the statute is written when it talks to transportation, because it refers back to section 7511, which is about transporting people who actually are patients, people who have been deemed eligible for emergency examination. And it expresses preference for soft restraints, for example, which when demonstrated in house healthcare, I think are more confining and more degrading than mechanical restraints. And I think the way that the statute is written, it's not clear what the protections of 7511 are, but I think that's an in the weeds argument that I want to state for the record, just to kind of almost preserve the argument, but not exactly thinking that that's something that you might act on. I want to just now, I'm also a person who's been subjected to one of these emergency detentions. And so I want to speak from that place as well. I was sitting in my office at the University of California, Berkeley, preparing, my lesson plan, and a police officer knocked on my door and said that he had received a report and he was taking me into custody because the report said I was a danger to self or others. Now, this happened in another jurisdiction. This happened in California. And when I told the officer that I was going to finish my phone call, he threatened to shoot me unless I came to him right away. And I share that story, even though it happened in another jurisdiction, just to say that these are traumatic experiences. And all the testimony that you've heard thus far has always assumed the person, quote, needed care. I actually ended up representing myself and, getting out of this because it was misapplied to me. The person who made the report was doing so in a punitive manner and lied about the actions. And that is my concern about relying on non-personal, non-sworn statements from third-party alleged witnesses. And I'll just talk about the case that was presented to you about the sister who calls and says her sister, who has a diagnosis of mental illness, had assaulted her. I think probably everybody who has a diagnosis of a mental illness has experienced somebody using their mental illness to say that that's why they got into a dispute. It's always the first thing. It's like, oh, that person has a mental illness, because it allows people to just dismiss whatever they have to say. I have a sister, and many of you probably have sisters, and sisters fight regardless of whether they have a mental illness or not. And part of the reason that we have these due process safeguards is to prevent kind of erroneous deprivations of liberty. And there's no other instance in the law in Vermont where people can file affidavits based on knowledge that's not personal. You've spent some time working on the Extreme Risk Protection Order Amendment. And in that case, you have to have an affidavit under penalty of perjury, all based on personal knowledge. For requests for relief from abuse orders, they also require affidavits. They have to be based on personal observation. They have to be based on personal knowledge. And all the law, I can't think of any exception where affidavits are acceptable that are not based on personal knowledge and personal observation. And so I think it deprives a person who's presumed to have mental illness of due process of law and equal protection to allow the deprivation of their liberty based on hearsay, essentially, based double hearsay, because the affidavit itself is hearsay, but based on the reports of somebody else. And finally, I just want to note, because the time is short, that under the current practice in the warrant for emergency examination application put out by the Department of Mental Health, it does provide that the person who is the subject of the application, they refer to them as a proposed patient. They say that the person can't be taken to the hospital without the warrant. And this proposal would change that, I believe, in an unconstitutional way. And finally, there was some allusion to a stakeholder process, and somebody said that Mad Freedom participated in that. I would say Mad Freedom attended the meetings but did not participate. Those meetings were highly partisan. They were hosted by the Vermont Care Partners, who was interested in changing the bill to suit its own guild interests. And I found it very difficult to participate in that process, particularly about the way they talked about people with mental illnesses. I thought it was very degrading. So I don't think that is, I wouldn't count that as a stakeholder process that was effective in soliciting all the views and needs and rights of everyone involved. And I'm asking, what I was proposing, and what I propose is that instead of amending this law, which we agree that needs to be amended for many reasons, that we do an appropriate summer study about the statute that's facilitated by a neutral party, where all stakeholders are in the room, to propose a revision to 7505 that doesn't conform the law to the practice, but ensures that the practice conforms to the law and the US Constitution. So thank you.
Thank you very much. Joe?
Thank you, Walter.
Make sure you talk as loud as possible.
Oh, yes, I'll also turn this way as well. I was wondering if you could tell us sort of what would your ideal version of this law look like? What would be what you would want to see if we were to do that summer study group? What would you want to see in that law that you feel would satisfy you from a constitutional perspective and the other perspectives you've spoken of?
Yeah, I would. There are two avenues to take a person into, custody for emergency examination. The first avenue is if an interested party, which is broadly defined, can do a written affidavit based on personal knowledge, and then a physician does a certificate, and the affidavit and the certificate form the basis to authorize the transport. So that's one avenue. The second avenue, I always think, is an emergency. I mean, a true emergency where literally the statute says you have to take them into custody because unless restrained, they would harm themselves or others. And so I would say that the second part of this statute should be limited to those true emergency situations where law enforcement officers out they have to, the person is going to harm themselves or others. And so that's when that would come up. But to comply with the law, I think in any situation when that non-certificate from a physician, it has to be based on personal observation. it has to be a true emergency, where literally the person has to be restrained or the harm will occur. I mean, that's what imminent harm means. And it also, we would develop what the person would be told when they're taken into personal custody. Something like a Miranda, right? It's not Miranda, but it's saying you are being held on an emergency basis because there's probable cause to believe that you are a danger to yourself or others. You are going to be taken to a police barrack until we write a warrant, which would allow us, and if a judge signs the warrant, we are going to be taking you to an emergency room to be examined by a doctor to determine whether you're going to be held further. I think the statute needs to say whatever that is that person is told. And then I think the statute needs to not allow any transport to any other place other than a police barrack until the warrant is issued, because the person is not a patient. The person is not a person in need of treatment until the warrant, a Superior Court judge has signed that warrant. And also, I think that warrant should have an expiration date because people's conditions change. And just because on day one, when the warrant was there, the person might have been immediate risk, by day 5, when they get around to serving it, or day 7, the emergency no longer exists. What's happening now also, I mean, I don't find Karen Curley's testimony persuasive in terms of a delay in getting affidavits, because people who are being picked up now experience long delays even before they're transported to a hospital. I was at a training held by Team 2 on March 29th up in the Northeast Kingdom, where a deputy sheriff reported that, a mental health worker had called him up and asked him to pick up somebody, and they were going to write a warrant. And the question that the deputy sheriff asked was, how long do I have to hold them? I spent 10 hours. And so, holding someone 10 hours before you write a warrant, I don't know why you can't use those 10 hours to get affidavits based on personal knowledge, if they're needed, if you're relying on that to support the warrant. So those, and then finally, I would not treat a proposed patient the same way I treated a patient. And so some of the transportation options would be very limited in terms of where you can take them and how you can take them. Any statute that I created would define what temporary custody would mean, and I probably wouldn't even use the word temporary custody because it has no meaning. I would just say emergency detention. If we're going to continue to use this term unreasonable delay or whatever that phrase is, I would subject it to the definition. And those are the thoughts off the top of my head. But I also, I think you have to remember that the whole purpose of this procedure is to make sure that people's due process rights are observed, and their Fourth Amendment rights are observed, and that reduce the possibility for erroneous detentions. And so I think it's really important to have a strict procedure that we adhere to, both in law and practice.
Thank you very much.
Thank you, Wilda. I just had one question. It seemed like some of your concerns were more in the application than in actually the law. And there definitely are, I definitely recognize your concerns related to the amendments and the law, but the subsection A does require personal observation and immediate risk. And it just sounds like that's not what's in the warrant application. It's not asking for what the statute actually asks for. Any comment on that? I mean, I do understand the other points, but
I mean, yes, I think it's a fair summary of my testimony to say that I'm concerned about the current practice. But I think why it's relevant is because the proponents of the bill want to make the current practice the law.
Right, gotcha.
And that is problematic because it's our belief that that's unconstitutional. And I also just think there's some problem. I mean, I don't think this is a very well written bill. It was written in 1967. I mean, things like temporary custody should have a definition. The legislature uses a similar term called protective custody when it comes to taking people who are inebriated into custody, and it's really well defined. And I'm looking for something similar in this bill, that it's well defined and people aren't arguing in the field about what it means. And like I said, I would avoid that also. And I also think, like I said before, I think that even in the current bill, I think it suffers from some vagueness that, while maybe not outright unconstitutional, certainly flirts with it, given that it doesn't reasonably provide any notice about what it means.
I appreciate that. I don't see any other questions, so I really appreciate your time, Wilda, and maybe circling back around to as we continue to look at this, as we get some quick answers on how to deal with some of these issues, because I definitely appreciate your concerns.
Well, I appreciate the opportunity to voice them. Thank you for your attention.
Thank you, Wilda. Have a good weekend.
Likewise.
We'll go to Jack.
Okay. Thank you, Mr. Chair.
Thank you, Jack.
Members of the committee. Thank you for the opportunity to come here and testify about this. So, I appreciate the concession that the proponents of this bill are willing to support our second proposal of amendment about the time limit of the warrant. And so, that being the case, I'll just confine myself to talking about our first proposal. And I believe you have the memorandum from me about this proposal. To introduce myself and give a little bit of information, I know I've been here before recently. I'm Jack McCullough. I'm the director of the Mental Health Law Project of Vermont Legal Aid, and we represent everybody in the state of Vermont who is subject to involuntary mental health proceedings. And involuntary mental health proceedings are a little bit unusual because I think people might assume that the person is out living their life and then a court process is started, and if the court rules in favor of commitment, then the person would be picked up and taken to the hospital. And in fact, the way virtually 100% of these cases happen is that the person is taken into custody pursuant to a statutory process, and they then are held in the hospital, and everything in court starts from that point. And so the entire commitment process occurs while the person's already in custody. And I've been doing these cases since about 1994 when I became the director of the Mental Health Law Project. And for many, many years, there are two ways that a person can be taken into custody under the statute. And they're in sections right next to each other, 7504 and 7505. And 7504 is application and certificate for emergency examination. And it's often referred to as an EE, or a 72-hour hold. And for many, many years, this was by far the standard way that someone would be taken into custody and hospitalized. And it provided, 7504 provides that there need to be two documents completed to justify taking the person into custody. One is an application for emergency exam filled out by a mental health professional. And two is a physician certificate from a doctor who says, I examined the person and I agree that the person appears to meet commitment criteria. And back when I started doing these cases, and for many years, this was the normal way it happened. And literally, the crisis clinician or the mental health screener and even the psychiatrist would go out to where the person is and talk to the person and come to some kind of evaluation about whether the person needed to be hospitalized. And if they did, they would fill out the application for emergency exam and the physician's certificate. And once those two documents were both completed, then they would have the legal authority to take the person into custody. And I know none of us have doctors that make house calls anymore, but the psychiatrists at community mental health centers literally would go out to meet with the person in their home or wherever they might be. And I think that that was really a much better way to evaluate people because you can see them in the setting that they live in, that they're allegedly doing something dangerous in, and they are probably more comfortable and more willing to engage. And so that happened for many, many years. And the other process that we're talking about here, the warrant and certificate for immediate exam, was rarely done back in the early years of my practice, 80s, 90s, early 2000s. It didn't happen that much. So when we hear, well, if there were a problem, why are we only seeing 2 cases in 40 years? Well, these warrants didn't exist very much 20 or 30 or 40 years ago. It was mostly the EE applications. And so the warrant process that we have now requires, and it's right in the first sentence of the section, in emergency circumstances, where certification by a physician is not available without serious and unreasonable delay, and when personal observation of the conduct of a person constitutes reasonable grounds to believe that the person is a person in need of treatment, and it goes on from there. That is what is required to support the application for a warrant. And the very comprehensive testimony of your counsel is very clear that the requirement of personal observation, that the warrant be based on personal observation, is what saves this process, is what makes it constitutional, because the judge has received a statement of facts that were personally observed by the person who's applying for the warrant. And this is a very important thing because the judges get these applications and they rely on them. And they rely on the allegation that this happened and I know it happened because I was there and I saw it. And we never really, in my office, we may or may not agree with the particular case, but the person saw what they saw. There's not much we can do. And as time went by, more and more cases got initiated by warrant. More and more involuntary admissions were initiated by warrant. And this past fall, we had a case where one of our clients was picked up and taken to the hospital, and the warrant application said that what makes this person dangerous was that she started a fire in her apartment, and that was obviously a danger to herself, danger to everybody else, in the building. Could have burned the building down. And this might have happened over the weekend, I'm not sure. But by the time we got to investigate what really happened, we found out that this claim that our client had started a fire in her apartment, endangering the people in the building, wasn't even about our client. It was about somebody completely different. No fire in our client's apartment. Our client didn't start a fire. It didn't have anything to do with our client's apartment. And yet, the court had issued the warrant based on the claim on personal information, the personal observation that our client had started a fire in her apartment. And this, to me, appears to be just beyond outrageous. I cannot understand how anyone would think that this is either justified or that we should allow the law to continue to let something like this happen. And we never thought that this could happen under the law, because we always thought that the plain reading of the statute requires personal observation of the facts set forth in the warrant application. That's what the words say, that it has to be based on personal observation. And now we're finding, not only in this case, but in other, from the testimony of the Vermont Care Partners, that warrants are being applied for and granted not based on personal observation of the facts of the case. And so we think.
Can I ask a couple questions there about, actually one question is for Ben, just to make sure I understood what he was talking about earlier. Just confirming that the personal observation component of it is a critical factor for whether the seizure can be appropriate under the, for both. I guess we could talk about due process rights as well, but.
I mean, so under the statute, it's clear.
Yeah, that's what I mean. And under the statute, well, it apparently has not been clear to who's applying it, so.
I did come across a case in New York, or the case out of New York, I believe it went up to the Second Circuit, that says the statute doesn't necessarily complete the constitutional analysis.
Right.
If, say, for instance, the statute isn't followed, the conduct in the seizure may still be constitutional, because, as I kind of explained it, our statute, I feel like, goes a little bit above that constitutional floor.
Right, right. But I guess the question though is, I mean, is the fact of personal observation critical for this being upheld under the Constitution, or is that just something we want to make sure happens? And if you don't have an answer right away.
Yeah, under the Constitution, it's observations and information available.
Those observations could be interpreted as personal observation, or it doesn't have to be personal observation?
The way it reads is specific observations, and it's really an objective reasonableness standard. So there are other cases that can say, you know, for instance, in this one case, there was a doctor that had a long-standing relationship with the patient that was ultimately involuntarily apprehended, and it was based off the doctor's observations from that long-standing relationship that he conveyed to law enforcement, in addition to law enforcement's perception of what occurred at the time. So that was, I interpret that to mean the other information that's available in addition to the observations potentially of the people writing the affidavits.
Did in that case, the doctor was it a signed affidavit of the doctor, or just a statement, information you picked up from the doctor?
That I don't know.
Yeah, we just have to check that. So back on to you as well, Jack, is that, so I am understanding then that the language I'm looking at on the screen that you've proposed, which is in a very lovely aqua, I think, that is to make it specific what the understanding has been that you're saying was out there as far as the need for personal observation of facts, or having the supporting statement under penalty of perjury of somebody else besides law enforcement that saw it. Is that?
Yes, that's exactly right.
Okay. So it seems to me that the personal observation component of it, it would be great to know how much that's a Fourth Amendment requirement or due process requirement. I think that probably Wilda would argue that it's constitutional because she did. But whether or not it is, we may want to make sure that that's our requirement statute and make sure it's clarified, as you have said.
Oh, I agree with that, because whether it's constitutionally required or not, if we allow people to apply for a warrant and it's based on this this game of telephone that could be going on when person A talks to person B, who talks to person C, who then fills in the warrant, who then the judge reads it. They're setting people up for being detained based on misinformation.
Right.
And
Right. So
and we heard my friend Kristen Chandler say, well, one of the problems with the personal observation requirement is that it could put somebody in danger by requiring them to have personally observed what is being put in the application. And then we had 3 examples from Karen Curley. None of them demonstrated any way in which a person would be placed in danger, because whoever made the observation already observed it. If they were in danger at the time they observed it, well, that's already happened. But so I think that that's a specious argument. And the question is, well, what could happen here? And we've heard 3 examples from Karen Curley, and I'd like to go over all 3 of them to show why I don't think they undermine my argument. The first example she used was an assault victim calls 911, and the screener and the police officer both come out there to the scene. The screener is right there in the house with the person who's allegedly the victim. The screener has the form with him or her, and I emailed Panina the form that is used for an application of the warrant. It's a 6-page form filled out by provided by the Department of Mental Health. It's right there. There's nothing. There wouldn't have to be any delay to get the victim to sign. So for the first part, I just don't think that establishes that there would be any delay. The second example is that the sister is down in Massachusetts and she calls 911 and says, my brother is sitting by the side of the road in Vermont. He's got a gun in his hand and he's threatening to commit suicide. Well, the police show up, the police find him on the side of the road. He's got the gun and he's talking to the police and saying, I'm going to end it all. There's no point in living. We don't need anything from the sister. The sister, for one thing, hasn't personally observed it. The sister doesn't know that he has a gun. All she knows is what she's saying, what he might have said. And second, the police and the screener are there and they've observed the guy holding a gun in his hand and saying he wants to kill himself. That the personal observation of the police and the screener would fully comply with the current statute and by what we're asking for.
So I'm going to cut you off just a little bit. I don't think we need to have the third because I wasn't buying, I didn't see how any of those supported that concept to begin with. But I did have a separate question, and I agree with what you're saying as well as a concern, whether this is the exact best way to address it. But definitely, I think that, at least to me, it looks like something we need to pursue. But I did have another question. I meant to ask Wilda, but I forgot, but I can ask you as well. So a person, as I understood from Wilda, that a person doesn't become a patient until there is the warrant. So the warrant, as long as the warrant is active, that person can be considered a patient, or is there some time frame before there has to be an order of non-hospitalization or hospitalization, or actually, the commitment process?
Yeah, I don't think that really has the terminology exactly right, or at least she may not be exactly right in the way those terms are defined in the statute. And all the definitions are in 7101.
So what is, or so when does the person become a patient? If, you're not, you don't have to become a patient involuntarily unless there's some process that says that you're becoming a patient. So if you could explain that.
Yeah, and in the terminology of the statute, we generally refer to people as the respondent in the court process. What the statute refers to them as is the proposed patient. And so the person, for the proposed patient, up until the court rules that you're committed.
So,
but during that time, once you've been taken into custody, you are in what the statute refers to as temporary custody.
Right, got that. But when can you actually be forced to be treated at a hospital?
You can be held involuntarily from the first time you get into the hospital, and there's a little process that I'll talk about too. But once you're taken to the hospital involuntarily, the hospital has 24 hours to do what's called an emergency exam. And once they do that emergency exam, that sets a 72-hour clock running. And that's why they refer to it as a 72-hour hold sometimes. And during that 72 hours, if you're, three things can happen. They can let you go. You can sign in as a voluntary patient. Or third, if you want to leave and they think that you are not safe to leave, then they have to file what's called an application for involuntary treatment. And that has to happen within 72 hours. And if they don't do it within 72 hours, their authority to hold you against your will evaporates. But if they do, file that in the Family Division of the Superior Court within 72 hours, then they hold you until that court process is resolved. And so they've got you there, they try to work with you, they talk to you, they try to get you to take medications, but they can't give you medications involuntarily until after you're committed by the court.
Right, okay.
Sorry, can I?
Yeah, go ahead, Angela.
I want to understand that process. When you say they hold you, so they don't admit you?
They do admit you, and it's, you're admitted. And I know there's tricky definitions in insurance law and Medicare about whether you're admitted or not, but you're admitted and you're in the state's custody during that whole period.
Okay, and just again, so the hospital has 24 hours to complete the emergency exam. But then is it in addition to that 24 hours, they have the 72 hours to then figure out what to do next?
Yeah. And, if you are brought into the hospital and you're examined in an hour, they still only have 72 hours from that point. And so it gets a little tricky for the department on Fridays. Sometimes we get kind of a flurry of new filings on Fridays because the 72 hours might be running out over the weekend. And it doesn't carry, for this part, it doesn't carry over. The 72 hours is really 72 hours, period.
And so that process of 3 to 4 days potentially is kicked off by this process that we're examining right now.
Yep. It starts when the person gets to the hospital. Yeah.
And that kind of goes to the other language that you proposed in here about the 72 hours.
Yeah, I thought it was a parallel time frame because, as Kristen said, if the person is out of pocket for several days, we don't know what condition they're in at that point. So we should take a new warrant based on current facts.
Gotcha. Right, so
one other question that I heard that I want to address, because someone said, well, why is there any case law about what happens during this warrant period? And the answer is there isn't any, because it all happens so fast. And there was a case, a Vermont Supreme Court case called In Re MB, 177 Vermont 481, in which our client was taken into custody illegally. And we filed a habeas to try to get him out. But he's in the hospital during that period. The state's going through all the rest of the process, including filing the application for involuntary treatment. And what the court said was, well, by the time we get to here, he's not being held on the basis of the emergency exam. He's not being held on the basis of the warrant. He's being held because there's now an application for involuntary treatment pending. So whatever initial illegality there might have been is not reviewable. And so the Supreme Court, essentially put us out of the habeas business with this decision, but it also means that we're never going to get these cases resolved at that stage of the process. What'll happen is, any claim, any argument we might have that the detention was based on misinformation, we'll bring that up at the trial.
Gotcha. I appreciate your time. We're running out of time a little bit. We're going to go to Wilda really quick. Has her hand up and wants to circle. Since I did raise a question that I meant to raise to Wilda, I will give her the second bite of the apple this afternoon. And then we have to get to Ben Battles. So I really appreciate your time, Jack.
I'm at his disposal. Whatever else you need.
Thank you very much.
Wilda White again. I just want to quickly respond to your question about when does a person become a patient. I was speaking of the period between that they're held for temporary custody and until the warrant is issued, that they're not a patient. Patient is actually defined in the law in 18 VSA section 7.1.
We just lost you. Section 7.1. All of a sudden, we've lost your audio, although it doesn't say that you're muted. If you could put in the chat that citation, if that answers that question, we'll follow up with that.
18 VSA 710115.
710115. All right.
Patient means a resident or person in Vermont qualified under this title for hospitalization or treatment as a person with a mental illness or intellectual disability. Didn't check the pocket part, so if that's been modified recently.
Thank you, well done. Sorry that your audio went away. So we'll go to Ben Battles. Thank you for your patience this afternoon, Ben.
So, Joe, on before.
Yep. Yes. Yeah.
Sorry, to answer your question about the warrant. So that wasn't mentioned in that case, whether or not there was a warrant issued. And I've done a very cursory review of that section of New York law, and it doesn't appear to be sort of that bookend warrant requirement.
Okay.
So it's
all
not
right.
precisely analogous.
Okay. All right. Fair enough. Thank you. Thank you for being here.
Thank you. Good afternoon. My name is Ben Battles. I'm the Chief of the General Counsel Administrative Law Division at the Attorney General's Office. I've handled a lot of appellate and constitutional litigation for the office over the years, and I also teach a seminar on state constitutional law at Vermont Law and Graduate School. So, interesting conversation this afternoon. I thought I would just talk a little bit about sort of the constitutional implications that we've been discussing, and I break it down a little bit, sort of how I see kind of the different constitutional questions that are presented. And so there's as was previously discussed with respect to search and seizure, there is the Fourth Amendment of the United States Constitution and then Article 11 of our state constitution, which are worded almost identically. And although there's been some difference in interpretation, the basic touchstone of both those provisions is that they protect against unreasonable search and seizures. And so reasonableness is kind of the theme that runs through it, through both provisions and reflected in the case law. The main way that reasonableness is established is by the warrant requirement, which in both provisions says no warrant shall issue except upon probable cause supported by oath or affirmation. So if you're in the warrant requirement, that's sort of one question. What is probable cause? What needs to support it? So as I look at this statute, there's an initial seizure that happens before a warrant. So the question is there an exception to the warrant requirement for that initial seizure? And I think, there's under both constitutions, I think the relevant exception is largely the same, which is the special needs exception, which is there a special need of law enforcement that justifies this seizure or search, but we're talking about a seizure. And and then you look at reasonableness. If you sort of identify a special need, then you ask whether the seizure is reasonable under the circumstances. And on the federal side, I didn't see anything in the research that I found in our circuit or the Vermont Supreme Court, but across the country, I think every state has some version of this statute, an emergency hold, mental health warrant kind of situation. And there is case law from around the country generally finding that this sort of seizure does sort of implicate the Fourth Amendment, but it is justified either under the special needs exception or potentially the exigent circumstances, which is related, but that's usually more in the criminal context. So I think obviously questions can come up as to specifics on whether the application in a specific case is constitutional, but as a general matter, sort of protecting someone who's suffering from a mental health crisis from hurting themselves or others is recognized as a special need that can be an exception to the warrant requirement. And then you ask whether the seizure is reasonable, and I think that gets you into the length of the seizure and the other things that we've been talking about. And on the state side, it's largely the same test, although I wasn't able to find any Vermont Supreme Court cases specifically talking about the statute, but I'm saying State v. Murphy, which was a decision decided this February 2023, Vermont 8, a paragraph 51, where they just sort of quote the standard to get out of how the Vermont Supreme Court applies the special needs exception to Article 11. It says, whatever the evolving federal standards, when interpreting Article 11, this court will abandon the warrant and probable cause requirements, which constitute the standard of reasonableness for a government search that the framers established, only in those exceptional circumstances in which special needs beyond the normal need for law enforcement make the warrant and probable cause requirement impracticable. And again, it's going to be a reasonableness requirement, sort of analyzing that. So
what was that case again? This
is State v. Murphy. It was from this past February, and it's like 2023 Vermont 8. It was about searches for cell phone ping, so a totally different issue.
We deal with that here.
So that's kind of the pre-warrant question, I think, sort of falls into this exception. And then there's been a lot of talk about sort of the actual warrant application and what's required there. And I just wanted to flag that, I think the constitutional issue there is really, is what's presented to the judge, is that probable cause? And I think, again, you're sort of looking at everything that's presented in the warrant application package. And the judge is going to have to make a determination as to whether this amounts to probable cause. So I think, the discussions we've been having about personal observation, I think is what the court should be looking at. And, I'm not a criminal prosecutor and I haven't been involved in these mental health treatments, but, my understanding when I see these application packages in like an appellate case file is like it'll be a police affidavit and maybe supported by another witness affidavit, but he or she is summarizing their investigation, not necessarily having a separate affidavit from every witness that was talked to in the investigation, but you still have a sworn affidavit from the officer and perhaps from a witness or two.
So let me ask you a question. This may pass constitutional muster. But if we want to make a policy decision that in the case of emergency exam or examination in this kind of situation of somebody that might have a mental health issue, that we want to tell the court that you need to meet at least this bar for probable cause. I mean, it's getting into the court's business a little bit, but I think it's a policy decision that in this kind of situation, we don't want people hauled away if they have a mental health issue without having personal observation, which is in the statute already. But if we want to make it clearer, I mean, is there a problem in doing something like that from your perspective?
No, I don't. I think it's certainly within the rights of the legislature to, require more than what the constitutional minimum is.
Right, okay.
As a policy.
So I'm sorry, I interrupted you.
No, that's all right. The only, on the search and seizure, there's some discussion about sort of where the state constitution provides greater protections than the federal constitution. And the Vermont Supreme Court for a long time, has been willing to give a little more teeth to Article 11 than the U.S. Supreme Court has to the Fourth Amendment. And so, but it's generally been in circumstances as to sort of what is someone's reasonable expectation of privacy. So if, for example, there's a case that says, Vermonters have a reasonable expectation of privacy in their unenclosed land, where that's not the case under the federal constitution. Or, if you're stopped, on the road and searched, there's an automobile exception under the federal constitution where they can search the car under the Fourth Amendment, but under the Vermont constitution, you can't do that without a warrant. So those are some things. In this circumstance, I haven't, the test for sort of special needs seems to be comparable, at least at this point.
That's helpful. Questions for Ben? Not seeing any, I'll just ask another one. I didn't ask you to be ready to talk to this, but since it's kind of come up, what about the due process issues that we've heard as far as notice an opportunity or noticed an individual who's being picked up for this purpose, being told why that is the case and whether we should actually have a requirement for something like that? Any input on that or any of the other due process concerns that you heard about for today?
As far as, obviously the facts of every case is going to be different. You can have an as-applied challenge, but I think the initial seizure, I would think about in terms of the search and seizure provisions, and I think that sort of balance accounts for due process in that context. And then the continued confinement beyond that, I think, is what is where the real notice and opportunity to be heard concerns come in. And I think the longer that there is confinement, the bigger those concerns become until you are in front of a judge. And, Mr. McCullough was just talking about, the Title 18 provisions, which spell out the different timeframes. And I think that's how the legislature has thus far tried to accommodate, those notice and opportunity to be heard by saying, it's an emergency, and someone's a danger, they can be brought in, they need to be examined within 24 hours in front of a judge, or at least starting the judicial process within 72 hours. And I think that accounts for the due process concerns.
And then one other question is, as far as vagueness of what temporary custody might mean, if you have any viewpoints.
That's not something I had thought about before coming in. you know, I don't want to, it didn't jump out to me as vague in the context of this statute, where you have these other provisions that sort of define what the other custody options are. But I haven't researched that.
Okay, I appreciate that. And I think this kind of actually came up when we were kicking around S36, which you weren't involved in at all, as far as not really sure what temporary custody actually meant. Any other questions for Ben? I don't see any. So thank you very much. And I can give you 5 minutes, Karen, if you wish to have 5 minutes, because then we have Eric coming in here for a quick walkthrough of the version of S91 that we are going to vote on Tuesday. And we can have a discussion if we want. But before we do that, we can call Will's vote on the bill for thank you, Ben.
S14?
S14, yeah. Just 1 second, Karen.
Yes.
Yep. All right, so we're all set. Okay, Karen, over to you until Eric arrives. And if you need more time on this, seems to me that we might need a little bit more time on this anyway.
Thank you. For the record, Karen Barber, General Counsel of the Department of Mental Health. So I'll admit that the conversation kind of went a bit farther than I had expected it to today. So I'm not sure I'm prepared to talk about everything, but I do just in general want to make a couple points. One, the department's goal is to get people treatment as quickly as possible, while at the same time respecting due process. I think, as you heard, this statute has been on the books for years, and I guess I would say it is working. I think certainly there are always instances where things do not go the way they should. I think, as we learn in law school, and I think I even said this the other day, bad facts make bad laws, right? And so we want to be careful that we're not jumping to change a bunch of things, because there are a couple times where something went wrong. I do think that the version that you were looking at is not the version with some of the, I think version 2.1 was the version that DMH worked on with VCP, because quite frankly, we did have some kind of due process concerns when it came out of the Senate. And so VCP was open to hearing our concerns. Part of that was that language that was talking about they could take someone into custody and then apply for a warrant in due time, or however it was said. And to us, that was a problem, right? We needed to assure that the process had started. So we worked on language to assure that. Our idea of behind assuring that due process piece was a little different than the way Jack went. But we did feel like that was adding in some protections. I think fundamentally, though, the idea is not to change the warrant statute. It was to try to make things a little clearer so that people in the field had more clarity on what they could and couldn't do. So we firmly believe that the warrant idea itself is constitutional. I think, as Ben Battles mentioned, like they have them in every state, right? That there's a reason that these types of warrants exist. And it's because sometimes we need to assure people can get treatment when they don't want to accept it on their own. We always try to engage people voluntarily, but there are times when it's not possible. And I don't want to take away from Wilda's experience or anyone's experience. And we're not saying that these are not traumatic, and that we need to assure that we are always assuring due process and that people have a right to make sure that their rights are respected. At the same time, we also need to make sure that people can get the treatment when they need it, when they're not willing to engage in that. And so I guess I would just ask the committee, before you think about maybe making broad changes to the statute, to just kind of take a step back and maybe think about it a little bit, try to look at our new language in 2.1, because I do think that may address some of your concerns. And obviously, if you do have specific questions or you are kind of contemplating changes, I would ask that the department have more of a chance to kind of think about those and respond.
Okay. And I'll just ask one question, and then we're going to move to Eric. What about the concept of, with respect to legal aid suggestion on the provision that would make clear that when we say personal observation, we mean personal observation? Because it sounds like personal observations not being quite interpreted in the field quite the way that I think it should at least. And I think the legal aids suggested amendment gets to that. And you don't have to answer if you've not looked at their, but that's a question I have out there if you want to.
Yeah, I think I testified on this a little bit in House Healthcare. I think the department doesn't necessarily have a strong opinion either way. I think overall the department's goal is to assure that people are getting treatment when they need it. We hear the concerns of the designated agencies though, and what we don't want is for this to delay treatment. We do hear Jack's concerns too. So I guess I hope there's a way that maybe they could work together to think about language that would meet both their needs. Because again, overall, all the department wants to assure is that people are getting the treatment they need when they need it. So it's I know it's kind of a non-answer, but we've kind of put it on the two of them to kind of think about it.
That's often my answer, is putting it on other people to think about it, as you've known over the last 24 hours. So, so I appreciate it, Karen. Thank you, and have a good weekend.
Thank you.
All right, Eric. Yes.
So what are you thinking as far as potential circle back up on that, or?
Yeah, I think we all need some more thinking. This and looking at the bill and thinking about the testimony we got. The Fourth Amendment issue isn't jumping out at me as a problem, but I have to think whether we need to make any suggestions on any of these other issues or if it is out of alleyway. And also just thinking about some of those process issues that Wilda raised as well. I think we just need to think about it a little bit. So I will put something on for early next week. And I'll circle around to you as well. Thank you. Yeah. All right. Thanks a lot, Ben.
Thanks, Bob.
Eric, sorry to have you here so late, but every minute is precious at this time of year.
That's right. I was here anyway. I've been doing other things, which is good. So I knew you were taking up this afternoon. So Eric Fitzpatrick with the Office of Legislative Counsel. I think the plan is to just look at the quick look at the S91 amendment.
Yes, and also hoping if people have input from folks. I will tell you that this amendment was sent to Karen Barber, to Jared, to Jared. I'm going to get his last name mispronounced at this hour on a Friday afternoon. What's that? Bianchi. Thank you. And why not just say State's Attorney, DMH, Dale, and I understand Karen was going to touch base with the Defender General, and I have not heard anything back other than this looks good.
Oh.
So just wanted the rest of the committee to understand that I don't think nobody's come to us to say they want more testimony. What's the version we're listening?
It's 1.1 of the amendment dated April 16th. I may not have changed that date, but at least on the version I have, 4:01 p.m. That's the same one that everyone else has.
Sure.
It sounded about right.
Version if I have it. I think you put it on our desk and I've just lost it.
I probably threw it away on you.
So for background, though, I'm sure everyone recalls this is the competency to stand trial insanity defense bill. The big picture being that the two proceedings related to the mental health status of a defendant in a criminal trial are being divided up in a sense. They're being separated. They kind of are merged together in current statute. And the defense is a defense that's raised by the defendant, and that's the insanity defense, whereas competency is a threshold issue that the defense or the state's attorney or the court, anybody can raise that at any time and has to be established in the first instance before an insanity defense could even be raised. And that's sort of the rationale for dividing up, especially with respect to that initial examination or that initial psychiatric examination. The idea being that with respect to that one, it's the insanity defense is separated from that because that initial examination, competency, a defendant has to be competent in order to raise the insanity defense subsequently. So I think that was part of the rationale behind having that initial examination only deal with competency rather than sanity. So that's what's going on here in the big picture. So the changes, it highlighted in yellow, section 1, you'll see it's over on the top of page 2. And this deals with the insanity defense, not competency. So with respect to the insanity defense specifically, it's just clarifying the language. The provision is still the same, that the defendant, as I say, it's a defense that the defendant chooses to raise. And if they choose to raise it, then they're responsible for hiring their own forensic evaluator. That's the bottom of page 1. And over onto the top of page 2, provided, in other words, yes, generally they're responsible for hiring their own psychiatric evaluator, but if they're indigent, the state has to pay for it, and that's a constitutional requirement. So this is just clarifying. The state was a little general because the question is, well, who would that be then? So making clear that it's the Office of the Defender General who pays for it. My understanding is that that's a line item. They get that. They're budgeted money in order to pay for these. And if for some reason there was ever, a situation where they didn't have the money for it, then they would have a constitutional claim, but that's not it's not a problem with the facial language. It just would be something that hopefully never happens, but if it did, then that would be an option. So for now, just making clear that it's the DG's budget that pays for those evaluations for the insanity defense. Second change you see on page 2 is really just a technical clarification you see on line 4. Because the way the title of this section was written now, order for examination, under existing law, it's sanity and competency. But it's not going to be that in the future. If this passes, it would be only competency. So it's just clarifying that this is the competency order, evaluation for competency examination. Over on the top of page 3, this is the same idea for competency that I was just mentioning about sanity. In other words, who's paying for this examination, this initial examination? The language here had said examination shall be at the expense of the moving party, provided the state shall pay for the competency evaluation of an indigent defendant whose competency is at issue. So the proposal here is to just strike that language, go back to the existing process. That would leave the existing process in place, which my understanding is it's DMH, the Department of Mental Health, who pays for these initial examinations. So rather than introduce some language which some thought might be ambiguous, just leave it the way it is under the current process.
Can I ask a question?
Yes.
So you said that's being struck. I guess I don't have the version that has it struck. Does everybody else have that? You're saying that those lines, the examination, it's lines 5 through 7 are struck?
Yes.
Yeah. I don't have that version. You do have that version?
Draft 1.1?
It says draft 1.1 and it says 4:01 PM.
Oh, are you
I have
sure?
no highlighting or.
It's online.
Really?
Yeah.
Oh, you have, are you sure it doesn't look like light gray highlighting because it wasn't printed in color?
It's underlined, isn't it?
It's just underlined because I think we added it and now we're taking it out, right?
Oh, I'm looking at struck out 4:01 PM.
Okay, well.
So online is different than,
Can I see?
Yeah.
because I agree with Karen, which I usually do.
Oh, you're on the good list.
Representative,
I see.
you were looking at one of our
Yeah. She questioned my arithmetic.
Oh, sorry.
Well, that's perhaps a mystery for our, there have been, I don't know if you guys saw the email today, but there have been some very strange things happening on the website and various things today.
I'm pretty sure Mercury went into retrograde.
Maybe that was it.
Mercury is in retrograde, it's true.
I do that.
I just lost my highlighter, see, Mercury.
See? Yeah, there you go. Damn that.
It's under abandoned the room.
So what about on the same page? Is subsection E highlighted on anybody's version on the same page? Is there a new subsection E?
No.
Yeah, I'm looking online.
Yeah, I feel like I'm gonna need to print that.
The one that I emailed to you guys last night, that's the one you're looking at?
No, that's where I saw it struck, right?
Yeah,
Yeah.
that one that I emailed you last night has all this.
Yes, that was the updated version.
And that's also the one that I emailed to all of the, well, not all, like 4 or 5 of the witnesses who we needed to hear back from. So that's, and yeah, so that part's good.
So you want us to go to your email last night?
Yeah, that's the one that witnesses have, and that's the one that was posted.
I enjoyed that
what happened.
I enjoyed that last night too.
I hope you looked at it when I sent it to you.
Oh, I did, bro.
I was thinking of you when I sent it.
I could see that.
I would take a printout.
I would take.
I sent the crap out of it once I couldn't.
Yeah, interesting. Yeah, I'll take it for now. Thank you. I think you can keep going anyway. Eric.
Yes, I'm wondering, if people have subsection E at all.
So we could just talk a lot more about what we struck out. Some people.
It sounds good.
I don't think we finished.
True, we were in the middle of that.
Yeah. So you can finish that part.
Okay. So that language is being struck. My understanding is that there was some lack of clarity about what the first clause meant, right? The examination shall be at the expense of the moving party. Well, does that mean that if the court is the one who notices the competency issue, that the payment for this initial competency exam is going to come out of the court's budget? Or if the state's attorney, if they notice it? Whereas current practice, if I'm understanding it correctly, is that it comes out of DMH's budget. So since that's a little unclear, and again, the same issue that I mentioned earlier with respect to the insanity defense, saying provided the state shall pay for the evaluation and it defended, but not specifying which arm of the state that would be, seems like a suggestion is most efficient and clear way to do this is to strike the sentence and completely goes back to the existing process.
Yeah, the status quo is that
right.
DMH pays for it, but we're also covering them a little bit when we eventually get to subsection E. We help them a bit.
Does everyone see that on the version you're looking at? That there's a subsection E? Oh, excellent.
I see it on the line.
I still have problems with. I can talk about my problems.
Oh, I don't want any problems today. It's very serious problems.
It's a serious problem.
Tell me your serious problem. All right, well, let's hear what Eric says first.
Well,
and then send Joe the one that doesn't have subsection E, so we have to
gets rid of the problem.
Put the factory through it, you'll only send it to me.
Yeah, right.
No, it doesn't exist at all in one place.
There we go, we're fine.
There you go.
Yeah. We'll wait just a second. Karen is picking them up from the.
Okay.
So.
Well, I can speak generally about
yes, please do.
Generally addressing the topic of subsequent evaluations. Remember, we're talking about the initial evaluation, right? The first one when someone first notices that there may be an issue with the defendant's competency. But sometimes, as we've all talked about this before, competency is a fluid status. So someone might be competent at one time and later on be incompetent, and vice versa. Someone who's incompetent might regain competency later on. So as a result of that, sometimes there is more than one competency evaluation requested for a particular defendant because competency status, there may be some indicia that someone's competency status has changed. So it may be that someone thinks there should be another evaluation. So that's what subsection E addresses, that situation, not the initial evaluation, but subsequent evaluations. And the basic concept is that it allows the court to order a subsequent evaluation, but only if there is a showing of changed circumstances. You get that? So there must be some showing that some circumstances have changed in order for the court to order a subsequent evaluation. So in determining whether to order a subsequent evaluation, the court has to consider whether, and again, it's not dispositive, but shall consider whether a treating physician has provided clinical evidence indicating that the defendant's competencies may have changed. So if there's some clinical evidence out there that the defendant's competency may have changed, then the court has to take that into account. And then where's the sentence, the last sentence, that's really the gist of subsection E right there. There's also a provision that says this procedure is not going to limit the ability of the defendant to get their own competency evaluation at any time if they want to pay for it.
Oh, right. So wait, people are getting their copies.
It's kind of weird out.
Any more copies than just those? All right, doesn't matter. I'm good. We're going to keep on moving.
Did we run out of paper?
I'm looking on.
I filled it with paper.
Looking online.
Are we out of ink?
But you're looking online. You see it online, right?
Paper tray.
Sure.
All right, so I'm looking at it. Do you want to explain the language that we're looking at, or did you just do that?
I thought I did.
I was multitasking. So I've read the language.
Okay, or just press rewind.
So yes, Joe.
So let's imagine a situation where you have someone who has been evaluated for initial competency and has been determined to be competent. And later on, the court sees something and they say, oh, I'm worried this person might not be competent anymore. And they want to order another evaluation. Well, that person doesn't have a treating physician. That person has been deemed competent. And so they don't have a treating physician that would be able to provide clinical evidence indicating that the competency may have changed. And the word is shall consider. And so it creates a problem that you actually, if the person has been deemed competent and later found incompetent, this section puts them at a disadvantage. So my issue here is that I think that this could be better put if we said, after an initial competent determination where the person has been found incompetent, these things will happen. And so, because I feel like the intention of the section is to address situations where someone has been deemed incompetent, and we don't want to create a delaying factor where the defense continues to demand competency evaluation simply to delay the proceeding. However, if the person may have flipped from competent to incompetent, I think it's problematic to say that they can't get a competency hearing.
So I thought the same exact thing, and I took these suggestions from wherever we got them from.
Judge Zone.
No, it was Karen Barber that we got them from. And I talked to Judge Zone about that. And I suggested actually almost the same language that you suggested. And he said, well, no, this is understood that it is, well, I could tell you that the language about the subsequent evaluations is intended to provide for reevaluations when someone has been found incompetent as well as when someone has been found competent. The original language only referred to people who have been found incompetent, and I think it's important to not have language to suggest that you cannot do a reevaluation of someone who was initially found competent, has changed circumstances to indicate they may no longer be competent. This is consistent with Section 4817 in case law. Drope v. Missouri, 420 U.S. 162. Once a defendant has been found competent, the trial court must be able to, I just can't read. I'm just getting tired. The trial court must be alert to change circumstances that would indicate the need for a new determination of competency. So it's once they've been found competent, they have to be alert to that.
I think Judge Zone agrees with us because he's saying that it's problematic to restrict the power of the court, and this section would restrict the power of the court.
I see what you're saying, though, but well, not necessarily, because the court shall consider whether a treating physician has provided clinical evidence. So if the person is competent, there wouldn't be a treating physician that's provided any clinical evidence one way or another, right?
Yeah, I find this problematic. I don't like this.
So can we just add then for that? May order subsequent evaluation of a defendant to be performed by the Department of Mental Health only upon a showing of changed circumstances, in determining whether to order subsequent evaluations of one who has previously been found incompetent. Because I think that second sentence does really seem to be more just whether it's incompetent.
Exactly, yeah.
But if I keep the first sentence as it is, that is kind of capturing this concept that whether it's the person's competent or incompetent and they want a subsequent evaluation.
Yes, it's the second sentence I would.
Does that make sense?
Yeah, that's the issue.
Catch that, Eric? I'm suggesting in determining whether to order subsequent evaluations of the person who was previously found incompetent or something to that effect. I want that second sentence to just apply to somebody presently considered incompetent. Or
I do see what you're
presently under a finding of incompetence, however that makes most sense. Yeah, no, it makes sense.
Here, can I insert a quick question?
Please.
I was wondering this last night, is it typically incompetent or not competent? Or are those interchangeable, does it matter?
I think it's, I've heard them interchangeable.
Yeah, I've heard it both ways.
Okay.
Yeah.
I was trying to see if there was consistency.
We're looking for consistency in our law. Okay. We do strive for that.
So
Strive for that.
what about, though, occurs to me is that, what about, and I don't know enough about the underlying sort of chronology of how the healthcare situation would work, but isn't it possible that a treating physician, even for a person who was initially found competent, that because of the facts of a particular situation, a treating physician became aware of the fact that their competency may have changed? Like, would that never happen?
Yeah, I think my concern is I don't know what the sentence means. And what I mean by that is like, so what does it mean that the court shall consider whether a treating physician has provided clinical evidence indicating the defendant's competency has changed?
Right.
And the person doesn't have a treating physician because they were competent up until something occurred. They might be something completely unrelated to the circumstances we're in. Perhaps a problem that had previously been dormant rises to the top and they start presenting with psychosis or something like, I don't know. I sort of feel like that sentence might be, I don't exactly know what the sentence provides us because the court can only order DMH to do this on a showing of changed circumstances. Why does a treating physician have to be involved in that? I mean, that could,
I mean, it often, from what we've heard in testimony, could be the court observing that. If there's a status hearing, whatever, it could be that the defendant or, that their attorney all of a sudden recognizes that. So I don't think it's would be the treating physician. So, yeah.
So I hear now, and I hear you saying you don't want the way it's phrased to somehow indicate that someone who was competent to start with, in some way that is sort of a factor against the person. Mm-hmm. So what if it just said, in determining whether to order subsequent evaluations, the court shall consider, and then strike everything from whether to provide it, shall consider any evidence indicating that the defendant's competency may have changed.
That sounds good to me.
I like that better.
I like it better.
That's why you get paid the big dollars.
Yeah, someday.
Those days are gone.
Right. I'm sorry, I missed that.
Would you be willing to repeat that?
Yes, exactly. If I can read through what I just jotted down here. So it would be in determining whether to, so this would be, it would just stay as is up until, in determining whether to order subsequent evaluations, the court shall consider, and then you would skip right down to, and then just say, replace the word clinical with the word any. Court shall consider any evidence indicating that the defendant's competency may have changed. So if there's evidence that.
Sure, that covers.
Yeah, that covers.
I like that change because when I first read it, I had a different concern and I just thought, oh, we're asking for like a higher standard for subsequent evaluations. So that was how I interpreted it.
Right.
Yeah.
I think that's in fact what they were doing. And I see that I have a witness who will attest to that sitting in the corner. Identify yourself for the record, Shayla.
Hello, everyone. My name is Shayla Livingston. I'm the policy director for the Agency of Human Services. The critical reason to have it be a clinical reason is to avoid sort of the constant requests for reevaluation when there is clearly no clinical evidence that anything has changed.
So, and is it when somebody's incompetent, only incompetent in the reevaluation for competence?
Right, so I think so. Fair warning, I'm not a lawyer. I think so. But I think to get to a very human point that you were making about, so long as they have a provider. I'm wondering if we could address your concern about the person not having a provider by putting in that caveat, but keeping the clinical evidence. So that we're only doing it without clinical input if for some reason there's a lack thereof. Because anyone in DMH custody or under our care would definitely have a clinical provider, and we would definitely have that ability. And so I think we could maintain the intent of the change that we presented and also address your concern in an instance where for some reason this was happening and a person didn't have clinical oversight. So I would ask that the committee consider that, because I hear your concern, but the need is there to have it to avoid unnecessary reevaluation when there's clearly no clinical change in the person's presentation.
Right now, would be like any evidence.
Right.
That's kind of status quo. And we are trying to tighten it a little bit for reevaluation of an incompetency determination.
Right, but again, that's only if the person has been determined to be not competent.
Yeah, that's
right.
That still seems to be the second sentence is.
And it would also require a competency evaluation to get a competency evaluation. So, essentially, now a defendant whose attorney may feel that their competency has changed, has to present with a physician, even if we take out the word treating, a physician providing clinical evidence indicating the competency has changed. So you'd have to get a competency evaluation, pay for it, go to court and say, look, court, I got a competency evaluation that said this person's incompetent. So then they'll order a competency evaluation.
No, I don't think, I think if it's just with respect to somebody who is under a present order of whatever the terminology of incompetency is presently deemed or under an order that they've been deemed incompetent, that they are saying that no, that I suppose the state's attorney could say, no, they've gained competence, or somebody says that. And in order to have that determination, when the person's been deemed incompetent, they need to have some evidence. It's not saying don't do like a new competency determination. Just tell us the treating physician, the person's making progress. We think he's making progress, and we should order a full-on competency determination. I think that's how I read it.
Yeah, I don't know if we're thinking the same thing, Joe, and I hear what you're saying. So, but again, I'm wondering if this could be interpreted to apply to a defendant who was found to be initially competent and then subsequently degrades, their competency degrades, and now the court or an attorney wants to order a competency evaluation. They've already had an initial competency determination of competent. So they are not under DMH care. They will not necessarily have a treating physician. And as Joe is saying, this tells me that they would have to get a competency evaluation in order to request a competency evaluation.
No, it's not. So right, the way it is now, but if we narrow it to just somebody who is.
Okay, so that's the part I missed. Yeah. So
no, it's not in there right now. And that's the clarification I'm trying to make. And I'm going to ask Karen to straighten us all out on this and give us the answers so we can all go home.
Thank you. Sorry. For the record, Karen Barber, General Counsel of the Department of Mental Health. So I would ask you not to touch the language, and here's why. One, just to answer your question, I think the stakeholders worked really hard to kind of come up with consensus language. Second, to answer your question, yes, it could apply to someone who either was initially incompetent, became competent, or the other way around. Right. I think, as Shayla mentioned, what we're really trying to do is make sure that there's a higher standard. But importantly, this is only for DMH evaluations. That last sentence is the one that I think is really important and is going to alleviate your concerns. This section shall not limit the party's ability to secure their own evaluations voluntarily or under the Vermont Rule of Criminal Procedure. There is always a mechanism for them to get their own evaluations. If the defendant's attorney is suddenly concerned that maybe they're not competent, they can get an evaluation. They don't need the DMH one, right? They can get it whenever. This is simply when you're asking DMH to again pay for an evaluation and get on the wait list when people are still waiting for their first ones, there needs to be some sort of indication that it's clinically based. A lot of people are going to have treating providers, and I do think we could figure out some language where there could be some caveat. I think the language, though, does cover that. Shall consider whether a treating physician has provided evidence. Not that a treating physician must provide evidence, but whether they have. And if they don't have a treating physician, then the answer is no, they haven't, right? But someone in DOC, say, who has been found competent but is waiting in DOC, there are treating providers in DOC that could provide that testimony. So I do think that the language covers your concerns in a way that works for everyone. Again, we have worked hard to try to build consensus on this language, and I really do think it does address your concerns.
So before we go to Joe real quick, so the person could be in DOC and have been deemed competent, and they're coming back and saying, hey, I'm now incompetent. But I still don't see how a treating physician, okay, so a physician could actually say that, yeah, this person was competent, but is now showing signs of problems, so you should have a full evaluation. Is that?
Yeah, they're not engaging in treatment anymore. They've stopped taking medications. There's lots of ways that, again, the clinicians aren't going to determine competency. What they're going to be able to do, though, is give an indication of whether or not there has been a change in the person's clinical presentation to the point where it does make sense that maybe there has been a change in competency. Because again, competency doesn't just change unless there's a clinical reason for it changing, right? And so that's why we feel like the clinical piece is the key here. But I do think the language is flexible enough that if someone doesn't have a treating physician, then what happens is the court acknowledges that there hasn't been a treating physician that has provided that evidence. It doesn't say the court still can't order it if they want to. It just means that the court has to try to consider that if it's there. And again, both parties can always get their own evaluations.
So I'm curious, why do people or courts ask for or order a DMH evaluation instead of getting one on their own?
That is an excellent question, and it is a question we ask all the time because we don't think it's the best use of resources because they have the ability to get their own. We pay for them, so maybe it's a matter of funding, right? But the problem is when we are getting asked to do 4 or 5 evaluations on the same person for the same charges, and there's no indication that clinically they have changed, it just contributes to the wait list. And so what we're really trying to do is say, look, we really need to focus on the people who need real competency evals. And so we're just trying to set some standards around that. It's not denying anyone the right to get an evaluation. They are always able to get their own. This is simply limiting when DMH needs to arrange and pay for it to assure that the use of our resources makes sense, right? That we're not bumping someone who hasn't even had a chance to get their first evaluation because someone wants a second or third or fourth, but actually there's no reason to think that decision is going to change.
I think that, and you mentioned a moment ago the word whether. The word whether actually bothers me because it's actually not saying that we have to actually consider the evidence of the treating physician. It's just whether or not there is evidence from a treating physician. And so the point of decision making is, or not decision making, but a point of weighing for the court is, does this evidence exist or no, as opposed to what the evidence is. And I think that's another problem I have with
that makes sense to me. That's certainly, I think that would address our concerns and maybe your concerns if we flesh out like what it is they're looking at. I wonder if you could say whether if a treating physician has provided, and then add some sort of standard to the clinical evidence.
What if you just said shall consider a treating physician's clinical evidence indicating that the defendant's competency may have changed, comma, if any.
I think, yeah, that's.
That works.
That way.
Yeah.
Save the day.
So my first suggestion went down the tube, so I had.
All right, are we good?
Yeah, if any of the.
All right.
She said we're good.
Excellent. All right.
Thank you.
Thank you, Karen, for that.
And she's in Hawaii.
Are you somewhere really fun and nice and warm and we're just...
I'm in Florida, so
Well,
it is
here-
warm. It's hot here. Yeah.
Well, here it's 70 degrees and perfect, except we're inside here, so...
So is Karen, because she's on with us.
Well, that's true. Yes.
That is true.
He's trying to get away though.
I know.
I was curious. I was like, you're somewhere tropical. I couldn't tell.
I have a feeling Karen, because how much work has been going into this, that she'll probably stay for the duration until we're done. And we're trying to get done as fast as possible.
Thank you. It's important, and I really appreciate you all taking the time to do this.
I don't love the treating physicians.
I don't
It's a
think.
grammatic thing, but
I
I just.
wonder if we can just.
How about
Whether a
you could-
physician instead of treating physician.
I would have a. How about Karen, you still there?
Yes, I am.
Same idea, I just I think it reads a little better. Shall consider clinical evidence provided by a treating physician indicating the defendant's competency may have changed, comma, if any.
Sure, that would make sense to me.
Does that work?
It works, right? I just don't know, is a treating physician someone that has an ongoing experience with that person? I just wonder if we need the word treating, because a physician just can't be like, yeah, you're incompetent, I've never
Right.
seen you before. I was wondering if we need the word treating.
I don't know the answer to that one.
Do you know if we need the word treating? Is that like really, really important, Karen?
I mean, I think what you want is to have someone who's got some sort of a relationship with the person. Because
can
or else
leave
I
it.
think it's hard to kind of make that, because really what we're looking at is the person engaging in treatment? Are they taking their medications? Are they going to therapy? That sort of thing.
I think the if any language really addresses any problems we have there. So.
All right. I think proceed.
All right. Well, as Karen was mentioning, we've already looked at that subsection, including the last sentence, which provides that, however the language is phrased, the person can still get their own evaluation if they so choose. Last piece of that section is subsection F, top of page 4, and this addresses the situation of what if there's been an order for an evaluation and the defendant doesn't show up. And this basically provides an issue in that situation.
I remember some witnesses had problems with that, and I'm looking back at my notes and I unfortunately find them, but I remember.
Yeah, they did, but I think we fixed it.
Okay.
The court didn't like shall.
Mm-hmm.
And Matt Valerio didn't like shall either. And I'm trying to remember what else Matt said, but I thought we largely fixed, we certainly fixed Judge Zone's issue here.
Wait, but though, didn't somebody not like F?
So I like F. Do other folks in this room like F?
The proposed edit.
It's proposed, yeah, the proposal, the people didn't like the proposal.
And so this is the change version.
This significantly changes it. It has may. It says there's a qualification that the person has to have received notice of the evaluation.
Right.
And then fails to appear. And the main thing is that it says may. And it's
Okay, all right. I do
off the
remember
record, though we're
hearing-
not off the record. It's unlikely that courts are going to issue such warrants, it would seem.
So then it may not.
The word may makes it fine. I'm okay with that.
I think finding the.
Sorry, I'm getting punchy this late Friday afternoon. You should see me mid next week.
I'm sorry.
I know, that's what I mean. You're going to miss that. All right, so proceed.
Yes, the last couple of things are related to the studies and the reviews at the end of the bill. So we skip right ahead to section 7, page 10. Remember, this is the report that DMH and Dale are going to provide on a competency restoration program. And first of all, the report will be whether or not one should be adopted in Vermont. And if so, what it should look like. But so the change that's proposed is that under the version that you looked at last time, it just said simply that the DMH and DAO would prepare this report in consultation with interested parties. So this is identifying who some of those folks have to be. So you'll see those over on page 11. So it says who DAO and DMH are required to consult with, and the list is from line 6 to line 12. Chief Superior Judge, Commissioner of Corrections, Department of State's Attorneys and Sheriffs, Center for Crime Victim Services, Defender General. And then lastly, also adding a piece, lines 13 to 14, that as part of this report, consideration shall be given to providing notification and information to victims of record. So just to make sure that's part of the report. So that's section 7. Section 8 has to do with, you remember, another part of this bill is that it's having justice oversight look at the issue of these competency examinations to determine, remember there was some in the bill, I think it's the piece with the 1-year sunset that allows mental health professionals other than psychiatrists to conduct these psychiatric evaluations. I think it was like a doctoral level psychologist, if I remember right, with forensic training. But justice oversight is going to study, whether or not that's a good idea. Should it be expanded even further? But there's a technical change made to that study, and that's just because these initial evaluations, remember, are competency now; they're not sanity. There's just striking and sanity every time it appears because that wasn't accurate anymore. And then lastly, a new report on page 13, and this is section 9, and this is a report on the issue that we were just mentioning with respect to subsequent evaluations, cumulative evaluations. In other words, someone's been evaluated once, and what should happen when they're evaluated a second or subsequent time. And that's what requires DMH and DAO to report on that exact topic, to include recommendations on how to address competency. And this is line 14, recommendations on how to address competency evaluations of persons who have already been determined incompetent to stand trial in another matter, including whether previous evaluations may be used or relied upon for subsequent evaluations. And I think that's all for the changes.
All right. Any questions or any additional input on 91? We'll have the final language. I'm scheduling this for a vote, and we can, of course, have a motion on the floor, and then
Now?
we can on Tuesday morning, and then have a discussion.
Okay.
Or we can all discuss it right now.
I prefer an email about 11 o'clock tonight.
Fair enough. Obviously, it's Friday, so you don't have to look into it until Monday. All right. Thank you so much, and we'll adjourn until Tuesday at 9 o'clock.
Wait, I thought you said 7:30 in the morning we're going to start.
I was thinking that. We'll see how it goes on. We'll see how it goes on. Well, the rest of the week will be 8:30.
We'll see who shows up and who doesn't.
Are we offline? Yeah.
Are we offline?